Judgment.
Announcement of Judgment Oblique Order WPC 5398 oblique 2024.
The petition is dismissed.
Item 34, my lord. Maybe can upgrade it. She is in jail. Detention camera.
34.
34. Thank you.
May it please your lordship, I beg to mention item 3 and 4 of today's list.
You want an adjournment?
Yes, sir.
3 and 4. After?
Sir, any day for today only.
Okay, after a week.
My lord,
3 and 4.
I beg to mention item number 2, my lord. My lord, I pray for adjournment
How much time?
for after 2 weeks, my lord.
2 weeks. Okay. Item 2.
Back to mention item number 12, madam. Item 12.
12 years adjournment slip was given.
My lord.
Okay. Item 12. 2 weeks.
So I beg to mention again item number 33 of this list, Lordship. Probably the second half of the PSC matters will be taken up. So before that, can it be taken up early, Lordship, upgrading?
He's in.
She is outside, but your Lordship, I observed that if on earlier occasion hearing would not take place, then bail will be considered, Lordship.
Okay.
May it please your lordship, I beg to mention item number 23. Due to some health reason, my senior Miss F. Begum could not come today.
Okay. 23. 2 weeks.
What
Yes,
is
yes.
next?
Also, I'm praying for listing of a case for.
Listing, give it to the court master. Listing, give it to the court master.
That he's not interested within month, Lord.
Let him take a call because I am hearing this APSC matters. We really have difficulty in adjustment. The court master will know it.
Lordship, I beg to mention item number 15, Lordship. As my senior is out of
15.
station, Lordship. Adjournment matter for the day, Lordship.
15. Okay, 2 weeks.
Thank you, Lordship.
Your Lordship, I beg to mention item number 24. We have submitted the adjournment slip.
Yes. Okay. 24. 2 weeks. Yes.
Your lordship, I beg to mention for listing of a matter on Monday that
Give it to
already
the court master.
partnered by this.
May the lordship. Lordship, back to me, item number 36, lordship. 36. Lordship, kindly matter be adjourned for 1 week, lordship. 36.
36 is a review matter. It has been adjourned many times.
Lordship. 1 week, lordship, no, next week, date.
File on 14/11/2022, and thereafter a lot of adjournment has been taken by the learned counsel for the petitioner. So once again, the learned counsel for the petitioner has prayed for adjournment. So the prayer is reluctantly allowed. So it is made clear that if on the next date of hearing, no adjournment shall be granted, and if we do not, if the court does not get the assistance of the learned counsel for the petitioner, the matter would be disposed of ex parte. List on, give a date next week, Monday.
Deep level.
Spoken to item 38.
Earlier.
Okay. Pursuant to passing of the order dated 16/5/2025, it has been noticed that a typographical error has crept in paragraph 7 of the order, whereby instead of mentioning that inverted commas, the petition is dismissed, petition stands dismissed, inverted comma closed, comma, it has been typed, this petitioner stands dismissed. Next, according to the said part of paragraph 7. According to the paragraph 7 is recasted here and the next paragraph with the this same paragraph 7. Just see here, this same paragraph 7, only the word petitioner will be petition. Just record the presence of counsel. Give your name, will be court master. M. Khan. So there will be also one line. This order shall be read together with order dated so and so, passed on so and so.
Daily list item 1 for motion.
No representation from the petitioner. First of all the respondents are represented. First of all, lines of justice, the matter stands adjourned today. List in the motion column after a week. Item 5.
It is Lordship. Yeah, Lordship, I am impugning an ex parte order, Pascal and Tribunal. That order is.
You have to address us on delay and latches. We have posed a query of on the last date regarding maintainability.
Hey, Lordship, I am a motor mechanic, Lordship. I am a permanent resident of Udalguri, but for my work purpose, I sometimes work in Guwahati and I went to Bangalore also for a considerable period of time.
Chip, even there was miscommunication between me and my guest counsel. That is why, Lordship, the case was unrepresented and ex parte order was passed. And I came to know about the ex parte order only, Lordship, in the month of November 2024, when police visited my village house, Lordship.
You see, in page 9, you write that the council took that he will take care of everything.
Yes, Lordship.
And go to him. What will the court do?
I have taken that.
You have not mentioned anything about your conduct. Whether you had any duty to speak to your advocate,
Yes, it was my.
or it was only the advocate's burden to inform you.
I'm putting too much emphasis on that point, although I am feeling it. It was my fault. I admit it. I should have been more
No,
vigilant.
that statement is not here. You don't regret your fault.
I should have been more vigilant, Lordship.
That conduct you have not stated in your affidavit, by way of an affidavit, that you regret. You say that it was his duty and he did not inform you.
I am pleading that ground, but I am not putting Lordship emphasis on that point, Lordship. Yes, Lordship, I apologize. I should have been more vigilant, Lordship. But Lordship, yeah. Lordship, I filed my written statement, Lordship, along with all the relevant documents that's under my possession, Lordship. But the learned tribunal, Lordship, didn't refer any Lordship grounds that I have taken in the written statement along with the document, Lordship.
Lordship may call for the records whether this was and how many adjournments were taken, Lordship, prior to filing of the written statement. The opinion does not even has a whisper of the written statement next to the repetition, Lordship.
No, but you see here, if you come to the opinion,
Yes, sir.
this is at 19/6/2018.
And the written statement
This
is of 16.
No, written statement is of 6/12/2016.
Yes.
6/12/2016. So therefore, after these 2 years, time was granted. That is why we posed that query about maintainability on the ground of delay and latches.
Lordship will hear it on the ground of delay and latches, Lordship, then.
That's why we have posed that
Yes,
question.
Lord.
We are hearing on the
And it was not that the petitioner was not aware of the proceedings, Lordship, very well aware of the proceedings. The references of 2012, Lordship, only the notices were sent out late. Delay in latches of Karnataka to Chennai to Delhi. Delay in latches. Jonali Dasu Didiba. Council of Blame for Atudia. Jonali Das, 2018. $25 with Ajmin लिखो.
Yes, with that explanation, we are not satisfied.
Lordship, my only prayer is, let's say, one last chance may be given to defend my case, Lordship. Only I came to know about the expert order when police visited my.
You see, please read paragraph 9, what you have stated. You say that you could not, you failed to pay the day-to-day expenses of the legal proceedings.
Lordship, I'm not putting Lordship emphasis on that point, Lordship. It was there, but I should not have Lordship taken. But my main contention is that my main Lordship, yes, Lordship, I should have been more vigilant, Lordship. Lordship. So, another point, Lordship, I would like to urge Lordship for your Lordship consideration, Lordship. I have filed my written statement, Lordship, along with all the relevant documents. The learned tribal
Documents will come later. You are negligent, so why should we set aside the opinion of the tribunal?
My Lordship, I under my sincere apology, I should have been more vigilant, Lordship. I admit that, Lordship. Lordship, the moment I came to know about the Lordship, the ex parte order, I immediately applied for the certified copy, Lordship.
That cannot be a ground, Lordship. He is well aware of the proceedings, well aware of the inquiry report, of the reference, filed his WS. Conduct shows that he would never give any importance to the proceedings, is not worried about his citizenship.
You see, please come to page 39. At page 39, there's a court fee stamp. And the date on that is not very legible. I think it is 14/11/24.
14.
Yes, Lordship. It's 24 is clear.
14/11 or something. I read 14/11. It may be something else.
14/11/20.
14/11/24. And this writ petition was filed on 8/4/2025. Absolutely no urgency.
It's 14/11/24 on page 38. It's clear, Lordship.
Maybe I can't be very sure, but that is what it appears.
Page 38. It's
No,
it's
I understand.
Yes, Lordship.
It appears to be so, but I am not very sure. But you are coming here on 8/4/2025, so there was no urgency. You were declared and then you were very happy about it. 5 months is too a long time.
I had some. So, I tried my best, Lordship, to expedite the things, Lordship. And
No, sorry, we'll pass orders in the chambers. It will be dismissed.
my Lordship, on humble prayer is, Lordship, one last chance may be given, Lordship.
A chance is to a person who is vigilant.
Yes.
It's a very important issue.
Lordship, I would like to cite some decisions, Lordship, on this ex parte opinion.
So may I try to explain, Lordship, in his, the certified copy was applied, yes, Lordship, in the year 2024 itself, of the opinion, Lordship, but all the relevant documents, including the written statement, Lordship, that was subsequently
You see,
applied.
that is more damning because of the fact that you filed your written statement without documents. You are very casual about it then.
I have to file all my documents with the written statement, Lordship.
You see, we are just, you see, I have not personal experience. You are saying so, and therefore we are getting a question from your own submission. You said that later on you obtained copies. So how did you file your written statement if you did not have copies? And if you had copies
Lordship,
and filed your written statement, then the second copies were applied only for the for making out a case for delay.
Because in the month of February, I applied it. Anyway, Lordship, my Lordship, prayer, Lordship, on last chance may be given, Lordship.
No, we have heard your prayer. That's what we will consider and reject it. We are not impressed.
And the order-
Somebody tells that you are a foreigner. There is a reference against you. You receive a notice. You file your written statement, and then you say that I'm outside. After written statement, you get 2 years time. Yes, what is the citation you are referring to?
Lordship, one is for the sufficient opportunities were granted and continuous default thereafter. And only after giving adequate opportunity, the ex parte order was passed. This proposition is in WPC 1293 of 20,
PT?
1293.
Just a moment.
2020, no?
1293 of?
2020. Sarijan Nessa.
Yes, date of decision.
Decided on 5/1/2021.
Do you have the name of the parties?
Yes, Lordship, Sarijan Nessa, Sarijan.
S-A or F?
S.
S.
Sarijan NESSA. Sarijan Nessa versus Union of India.
If Lordship
If
allows me,
Lordship and one on the endless proceedings. That is WPC 8361 of 2019. Decided on 12/10/2020, Ijjat Ali versus Union of India Lordship.
12/10/2020.
12/10/2020, decided on.
Okay. IZZ80
Yes, party's name is Ijjat Ali, IJJAT.
double J.
Yes, Ali, ALI versus Union of India Lordship.
If Lordship allow me, Lordship, then I would also like to rely on one judgment, Lordship.
Let me
Definitely.
finish.
Pass it on.
Yes, all right.
Pass it on.
Lordship, then the other one which I would like to rely on, which covers all the issues taken up in the ex parte Lordship, that is WPC 291 of 2024. Decided on 23/2/2024. Baharul Islam. BAHARUL ISLAM, Lordship. Baharul Islam. Lordship, this should take an another one. If he's blaming the council also, for that also we have one. And that is for exceptional cases. That is reported in 2016 for GLR.
2016.
Yes, Lordship, for GLR
Yes.
82. Code Banu, KODVANU versus Union of India, paragraphs 5, 7, and 8, Lordship. Then the Lordship writ of certiorari, which is reported in 2023 SCC online, Central Council of Research. (2023) SCC online, SC 996. Central Council of Research in Ayurvedic Sciences, Lordship, paragraph 54 onwards.
23 SCC online, Supreme Court.
996.
Okay.
Central Council of Research in Ayurvedic Science. And Lordship, on the delay and latches part, I would like to refer to Mrinmoy Maitri, Lordship. That is 2024 live law.
Live
Yes.
law we don't have. You'll have to give us a
I will
doubt.
give you a copy, Lordship. That is SC 318.
What is the name of the parties?
Mrinmoy, MRINMOY. Maity, MAITY. Versus Chanda, Kole, and others. CHHAN.
Just a moment. Mrinmoy, I remember reading it.
Lordship, I have the civil appeal number also.
Will you mail it to the court master? We will
Yes,
get it.
yes. Paragraph 11 onwards is all on delay and latches, Lordship, in this citation. And it even takes up Chennai Metro.
We have it.
Yes, Lordship has it.
We have this.
We have referred it earlier also, Lordship. Karnataka Power and Corporation and this.
2024 INSC 314.
Yes, Lordship.
Which paragraph?
Paragraph 11 onwards, Mrinmoy Maitina, Lordship.
Yes.
Yes, paragraph 11 onwards, Lordship. The other two judgments which I wanted to cite are covered in this only.
Okay. We'll consider your judge, this citation, Bijoy Kumar Das.
Vijay Kumar Das lordship. The page number 3 is my lordship.
You have seen that. In the meanwhile, I've read it. It says that although the court is not satisfied with the explanation, but one opportunity was granted.
It is my humble PI lordship. Only one law may be given lordship.
We'll consider it.
Lordship order reserved.
Yes. But Mr. P.S. Raja,
B Bora lordship.
B. Bora, and Mr. B. Bora, and counsel for the petitioner. Respondents are there. But both sides of the issue of delayed licensing filing of the reg petition.
I think
So delivery orders, order reserved. Although we are reserving it, but if we have time, we'll dictate the order in the chambers. So please inquire tomorrow morning. If you can dictate it, then it will not be CAV, otherwise it will go to CAV.
Upgraded item 39.
Please check it with the courtmaster tomorrow.
Obliged.
May it please lordship, lordship kindly pass over the matter for the day.
Pastor, okay. Ask for the days, principal and counsel for the petitioner. Achha, just a moment, just a moment. Yeah, this record is there. No, this was to be listed along with the records. This was to be listed with 5240. What is this? Just give that record.
Monday. I received.
5240. Ah, yes. Verma,
Yes, lordship.
this is that matter we dismissed is
Monday.
5240. That writ petition was on time. So we issue notice and grant bail to the petitioner. You want an adjournment still?
No, lordship.
No, okay. Then you'll have to make some submission.
Lordship, the file is not with me.
This file is not with you. Next time, don't do it. You learn from this mistake. Never be in the court without file. Okay, your name?
A Jubaria. A Jubaria.
A.
Jubaria.
Dubaria. Oh, Jubari, okay. Jubaria, okay. Yeah, that means A. Jubari, then counsel for the petitioner. Also heard. Sorry. Next, madam, by filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the page 82, opinion dated so and so, passed by so and so and so and so. Thereby declaring her to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Next, prayer for bail. by the learned counsel for the petitioner is opposed by the learned standing counsel for the FT matters. Next one. Considering the projection made in this writ petition, 10 days time to take bail, rupees 5,000 to the satisfaction of SP border. Nagaon. List after 4 weeks on receipt of records. Next para, the
Record was here, Lordship, I think.
no records not here.
Record, because record was here last time. Lordship had said the registry will retain the record for a month. Ito case hote, aase dosa case hote. Can you dispose of matter asile likhe?
Just say it appears from the office note in WPC 5240 of 2024 within packet disposed of. Office note dated 3/04/2025 that disregarding the directions contained in the order dated 4/10/2024 to retain the records of the tribunal for 1 month from the date of the order dated 4/10/2024, the records have been returned. Full stop. The AOJ civil rule no, not civil rule, FT section shall put up a note as to why in disregard of the court order, the records of the tribunal was ordered directly to be returned. Next, be that as it may. A fresh requisition be sent for the records of the tribunal. Then list after 4 weeks on receipt of records. This paragraph will go where we have said call for the records. Huh? Okay. And just before this last line, list also says that this order be brought to the notice of the AOJ FT section.
Upgraded item 33.
What is the best document you have to connect to your parents?
Lordship, that land document and Lordship, that marriage certificate.
Where is that
Uh,
page?
Marriage certificate, your Lordship will find at page 54.
Abhinama doesn't appear to have been proved.
Lordship, that official has appeared and as DW4, he deposed, Lordship. Page 93, your Lordship will find.
93.
93. This document was registered. And page
Mr. Sharma, where is that certificate?
certificate, your Lordship will find page 54, Lordship.
54.
54. Type copy 54. 56 is the Xerox copy.
Mr. Sharma, in this case, 56 is the original one. This is exhibit number.
And it should six.
That exhibit F, Lordship.
Exhibit F.
Lordship.
This, because this entry is. Yes. You see, this is what has happened. You have seen the records. This way. Ah. There's something wrong. It will happen. Mr. Sharma, this is for you.
There are two Sharmas.
No, the
Senior Sharma.
the additional senior. Now you see what has happened here. It's a Kabinnama. Kabinnama gets registered in the sub-registry office. We don't know how. And then this is registered in a register of wills. And then there are overwritings.
No copy to procedural image.
Mr. Ahmed, you also look into it. Please go there and look into it.
No.
You'll have to address us because this is something we couldn't follow. If it's a Kabinnama, under the Assam Muslim Marriage Registration Act 1934, it has to be registered. And that is before the Sadar Qazi.
Net 56. দুটো বেলেগ কপি নহয় জানো?
No, because you see what has happened is that in the deposition somewhere he has stated that there are erasures. And that is why I thought that this is not proved in accordance with law, and therefore,
What is then the record is not with us. We just.
no, we
have
don't
a-
know it. You see, mistakes may happen. We are not, not on those things, but my anxiety is only if I missed it, whether I am losing my memory. Because Ms. Verma, when we read alone, we don't get assistance. So we may get, there may be something
something.
between the cup and the lip. We'll take it up after some time, Mr. Ahmed. We do some other work, please go through it. If required, we'll adjourn it and take it up day after tomorrow.
Otherwise, that land document is also there. Lordship.
Where is, show us that?
Land document, your lordship will find 36.
36.
6, lordship. And her name appears,
Her name is at serial number 25.
lordship. That she inherited her father's property, lordship.
But where is the father's name entered here?
Father's name, your lordship will find. Serial number 18, lordship.
Serial number 18.
18, Kamaluddin.
You see, here again, there's a small issue. That's why we couldn't understand. Serial, you say, is Kamaluddin. You come to serial number 11 and 12, 11, 12, 13. All these are son of late Kamaluddin. So therefore, before the name of the father's name, the son's name come as son of so-and-so.
Lordship.
Late Kamaluddin.
Lordship.
Are they same person? We don't know.
That, Kamaluddin. That, just
But we have not been able to follow that.
lordship, that I have understood, lordship.
We take it up day after tomorrow. We are not disbelieving you, but we want to have the record straight. We want to understand it.
Lordship.
If you want, even from the court master,
We would also like to go through it. My friend says
no, definitely. That's why we are taking up day after tomorrow. We go through it.
Friday, lordship can post it for Monday. Monday, no? Oh, Wednesday, lordship, because we also have some.
He's asking for bail. That's the reason.
But he's not in detention, lordship.
No, we understand.
Not because
He's outside, lordship, and nothing has happened till now.
That is a different issue. And even in fact, lordship, in paragraph 14 also I have stated that main grounds for suspecting, those were also not communicated to that.
No, lordship, that
Paragraph
is,
14.
We give a
Please.
protection that not to be deported.
yes, lordship.
Uh,
Opinion is of 22, lordship. Till now, she has not been arrested.
so whatever be, but once somebody is asking for bail, we are disinclined to give more adjournment.
Lordship will consider
Uh,
day after tomorrow.
Give us some time. They must have some difficulty.
Not to be deported, lordship.
Monday?
So,
We take it up Monday.
Monday is not there, and I'm also not there. Wednesday, lordship.
Okay. Uh, all sides are represented. With regard to court query on the on annexure 1. And this Kabinama was what, which page?
Page 54.
54. Kabinama. And annexure 6 to the 6 to the writ petition. The court is inclined to grant time to the learned counsel for the petitioner to address the court. Full stop. Next one, list on Wednesday. 28/5/2025. Next para. In the meanwhile, if the petitioner is apprehended, he shall not be deported out of the country without order of the court.
Sorry.
Next para, the prayer for bail shall also be considered on the next date of listing.
Outline.
List on so and so. If you want to go through the records.
Upgraded item 34.
Because Mr. Sharma, we are asking you to look into it because you'll have to address us having regard to the Assam Muslim Marriage Act 1934, which requires that the Kabinama must be registered with the Sadr Qazi or Muslim marriage registrar. So query to you would be how this was registered as in the sub-registry office and how it was registered in the register of wills. That is the court query. Yes, item 34.
Lordship, can this item be taken after some time? The records are there, but
My lord, my friend will 2 times inspected the record.
Mr.
I must inspect the record, my lord.
No, for the time being, he's not seeking adjournment. For the time
it's
being.
paying for some time, Lordship. We'll go and get the records. Yeah, wait a second. Going. আমি তো আমরা নড়ো নাকি
Admission item 6 with 7.
Chip 6 and 7 also we are seeking adjournment today, Lordship. আমার লগত আহিছে মানে আজি নকৰো ইয়াৰ সাথে
Yes, yes, lord.
6 record is
When?
with us, Lordship.
When?
Next week, Lordship.
Wednesday, lord.
Wednesday কিমান লম?
What size are represented?
Not Wednesday, Lordship, one day after that.
No, Thursday again, there's a special bench.
Right.
Friday.
Sorry.
Lordship.
Friday, okay. What size are represented?
List on.
On the prayer made by London Standing Council for the FT matters. This matters since adjourned today. List on, make it Friday.
RT/5.
আর একটু ওই থাকা না আর এইটো আমি টাইম লম
No, 240.
আমি স্যার
No.
8 also, you are having the
Yes, lord.
Complex.
yes, item 8.
Item 8, lord, I have seen the record, lordship.
Possible for time being, signature na other court.
Time being, okay.
Record, yeah.
I keep asking if you are not that record. Hmm.
Item 9.
May I please, Lordship? Lordship, I'm extremely sorry. Lordship, kindly adjourn the matter for the day, Lordship.
Prayer made by land counsel for the petitioner, matter is adjourned today. List after 2 weeks. Ms. Verma,
Yes, Lordship.
if you have the brief,
Yes, I have
please,
it.
please look into page 23 when you address us next.
Lordship.
23.
Yes. Next 23/7/18.
Page 23.
Page 23, Lordship.
The next date when you address us, just make a note.
Yes, Lordship.
It's not an exhibited document.
Lordship, our presence may be recorded.
Have you said all sides?
Yes.
Okay.
Lordship is
So if required, through your channel, you can get information about this document. It'll be okay.
Lordship, interim is there, continued.
Pardon me?
Interim.
No, I don't think interim is required to be extended. Just see the last order.
Yes.
It is limited to,
Yes.
no,
Also,
we can look. Limited order.
yes.
My page 23 is not even legible, Lordship.
We understand, that's why. This bail was granted for an indefinite period. You want it to be limited till the next date of listing?
Yes, Lordship.
I
Lordship.
think Lordship should allow her prayer.
Lordship, actually, I have not filed Lordship. Lordship file has been lost. File has been misplaced, Lordship. I have not seen the order, Lordship.
No, file is misplaced, but your alertness should not be misplaced.
Yes, Lordship, sorry.
Always be alert in court. You may land before straight people like us, you may land into trouble. Okay, next.
Obliged.
না এতিয়া নহয় গুঞ্জন আনিব গৈছে
Yes, item 10.
Your lordship.
Yes.
My lord, earlier a wrong record was come, my lord. And now, my lord, the record has come, actual record. Because of that, my lord, in the final order, it is stated that FT case number 307/2010. Actually, my lord, it was 301/2010. Because of that, my lord, let's give me see.
We did not follow you. Please repeat again.
My lord, earlier record in connection with this case is come, my lord, but it was not matching with the case, my lord. Therefore,
Okay.
this honorable court called a report, and accordingly now a report come, my lord, with original actual record and discrepancy which was, my lord, in the final order of the FT case, my lord, and this was 307/2010, and accordingly that record come, my lord. That record is different, and actually that would be, my lord, 301/2010.
It should be 301.
Yes, my lord.
It's a serious mistake then. Ms. Verma,
yes lordship
page 17 is the opinion.
Yes.
I'm yes 9/4/2018 it will be 301
301.
did you file your WS
Published to file for-
so if he had filed lordship he would have had the correct number I'm trying to find out if he had
But
filed
no, he may have filed something, but he will go by the opinion. In the
No.
opinion, if it is 307, any counsel will write only that.
What I meant was lordship, if that record, which is before lordship, the number is 301
No,
Now
in this,
301 come.
now 301 has come.
in his name,
Yes.
We have not checked that,
Jiben Devna.
but here also the opinion is 307.
Okay,
This is it.
This is a different manner, one state versus original. I have checked the record, man.
We are sending you, but this is very serious.
and lordship, why after such a long time you realize the records are different?
No, because the records did not match. He's saying that
No,
last time when the
please,
records came,
I remember lordship,
Ah.
incorrect records had come.
now we have flagged it.
Hmm.
Here also the same mistake is there. It's 307.
Will lordship may retain this and even ask for 301. This is what I feel, so that both
301 is here,
and
but the opinion is 307.
307, okay.
Clarification basis.
It's in your name only. Yeah, only the case number is.
যে কল করলে বেলেগ এটো রেকর্ড আহিব 2070 টো বেলেগ এতিয়া সাবসিডিয়ারি টেকন করে
Lordship, what I feel is the deposition and all has 301 written. Maybe it's a typographical error in the tribunal, Lordship.
No, whatever be, but
Because the reference, the first notice which went out, that's also 301. It could be 301, could be 307.
no, but you see what has happened. Why we are anxious, Ms. Verma? Look at the second page of the opinion. That flag burn. This is 307. The last line, opinion is of whom?
even they have nothing.
Jiban Devnath, the proceed is Jiban Devnath, Lordship.
Son of Radhasham Devnath.
Jivan Devnath.
Yes.
But all that apart, there's a mismatch in your name and therefore there's a big gap from 1966 voter list. So it doesn't help you otherwise also.
My lord, the things I have checked, when check the record found, my lord, and I also mentioned, my lord, there was earlier, my lord, proceeding against his brother, my lord. And, that, my lord, opinion was in favor of the brother, my lord. And it is also in record, my lord. In the written statement also mentioned about that case, my lord. But that was not exhibited. And, in the finding also, there is no mention about that case, my lord. That was, my lord, FT case number 47/2010.
No.
In page 36 of the record, my lord. 44.
Where is your written statement?
My lord, written statement, lordship will find page 35, my lord.
Page?
In the record, my lord.
Page? Acha, in the record.
Yes, my lord, I did not report the annex. my lord. In the written statement, my lord, in the para 9.
Para 9,
In
yes.
page 36. my lord.
59507.
Yes. And that was also in record, my lord. That opinion also, my lord, mentioned in the last part of the my written statement. There's the documents.
Is your evidence enclosed here?
Well, that could not able to annex, my lord, at that time.
We are sending you the records. You have checked these records?
Yes, my lord, evidence is there.
In the evidence, you have not exhibited those, that opinion.
That was not agreed with, my lord. But in written statement, my lord, as a document, it is written there in the written statement.
But how does it help you if you have not given evidence? Presumption will run against you.
My lord, when my elder brother is, my lord, with the same document, my lord, is Indian, my lord. So how can, my lord, my brother, my lord,
So definitely, if you don't prove it, you lose.
that part, my lord, was not how, why.
If you ask me to
Yes.
to answer this, I'll be able to do it.
No, my lord, but that was the fault, my lord, not exhibited, my lord, and there is
No,
no.
what we don't know, we can't make any comment against learned counsel.
My lord. But
Bar will be against us.
lost.
That how
But my
without
lord, in
how
the-
without hearing them we came to jumped into an opinion.
My lord, in the voter list of 2016, my lord, his
Yes.
name along with his father name appeared, my lord. That was,
No, but 2016 doesn't help you. You are disconnected.
but
After 66, you are disconnected.
so my lord, opinion is that I could not able to, my lord, connect the link, my lord.
Yes. But that is Nitai Debnath.
Yes, my lord. In voter list 2016, my lord, Jivan Debnath, was late Radhasham Debnath. But in the voter list of, my lord, next page 13, 1997.
Nitai cannot become Radhesham.
So instead of Radhesham Debnath, it written as Radhesham Nath. And his father
No,
name
no.
is Nityanand. Page 13.
No.
And mother is
Where
Haripriya.
is 66 voter list?
That is, my lord, page 15, my lord.
Page 15.
Vernacular is, my lord, page 16.
Yes, 16 is Nitai Debnath.
Nitai Debnath.
Who is Nitai?
My lord, Nitai is the, my lord, my grandfather.
Documented. No, can I link to maybe the one side. 66 of the document. This one.
Any voter list of your father and grandfather together?
No, my lord.
Then how you are connecting your grandfather to your father and father to you yourself? Based on which document?
My lord, that is, my lord, the voter list of 2019, 1997. Radhesham Nath, but it is.
Which page?
Page 14, my lord.
But then this is not Debnath.
This is not Debnath, my lord. It is written Radhasham Nath. That was the discrepancy, my lord. And his father name is Nityananda.
Just a moment. Nineteen 1997, what is the name of the village?
My lord, it's a, 1997 my Guwahati, my lord, Jalukbari. In the year 2005, my lord, they went to the Lakhimpur, whole family one. And when they
No,
are
no, you go
citing
through
their-
your evidence. We are not finding a link.
It's no link, Lordship, at all.
But go through it since,
Right, confusion of lines. Discrepancy, all of them, discrepancy.
Mr. Sharma, you have flagged the evidence is in the first flag.
মোৰ জন্ম কামৰূপ জিলা গুৱাহাটী মৌজা।
No, that shifting, whether it says, you has stated that.
Yeah.
Doesn't appear to us. You perhaps had a good case, but performance of the
Yes, yes, bro.
council on record. Perhaps has no trial experience.
Yes. My lord,
We are in fact saddened that people don't know how to look at the records.
my lord. End of justice, my lord.
Even, no, ends of justice to what extent? Even you don't, you have seen the record, but you have seen it half-heartedly. One of the best documents you have not seen. You are introducing Shankar Devnath as your brother.
Yes, ma'am.
And the best document in the record, you have not seen that. The summons of the tribunal was received by Shankar Devnath. At the back page, you will find that. We'll take a short break and come back.
সম্পদ ডিক্লেয়ার করেছে আর নোটিছত উল্লেখ থকা ব্যক্তিজনক ঘৰত লগ পোৱা নগ'ল তেখেতৰ ভায়েক শংকৰদেৱ নাথে মোৰ ককাইদেউ হয় বুলি চিনাকি দিয়াত তেখেতৰ নটিচৰ সকলো কথা বুজাই দি এটা কপিও তেখেতৰ সাক্ষ্য লৈ আনটো কপি মহামান্য আদালতলৈ প্ৰেৰণ কৰা হ'ল মানে শংকৰদেৱনাথে নিজৰ
So this is received by him.
yes yes Lord.
Therefore, there is a connect.
yes yes
But perhaps the council does not know how to.
yes
And in the last page, we have also flagged the opinion.
yes
He has filed it.
শংকৰদেৱনাথ opinion
Opinion, yes, there. Third tag, yes. Because even if you don't go into the contents of that opinion, after this case of Bikartan Das, even if you don't go through it,
Yes.
but then again, when the person receives the summons, then there is a link.
And he himself has stated, Lordship. He is the brother. He himself has stated.
In his evidence also stated.
So
We are considering a remand in this matter because because of the fact that brother has accepted the
Accepted,
summons.
yes.
Therefore, let him get a chance.
observation that this opinion may also be looked into, the brother's opinion. Hmm? No, Doctor can even clarify about 307 and 301 because in some, yes, that will need a clarification.
No, but now there will be no mistake. In
No,
fact, because
Because
the
that-
tribunal has taken note of that and then
Yes.
sent the records.
Just a line, Lordship.
Third, Mr. Jiuddin, learned counsel for the petitioner, also heard. All the respondents are there, Mr. Islam on behalf of AIRE.
Lordship, had he argued the case, it would never have been remanded back. Lordship has given him this relief. He has not done any hard work on this, Lordship.
No, that is what that is why we said it saddens us when we find that the trial court records are not gone through very seriously. Because we both are from trial
Civil
court,
background, yes, Lordship.
not civil background, but trial court ultimately. So I was just remembering, I was not having much experience. As a junior, I was in the court. And it was the court of Justice J.N. Sharma. Learned counsel was just going through the records, LCR, and he disliked it. And his first words were, "You don't know how to find the records." Then he saw everywhere. I was there sitting behind, called me and then said, "Find out this record." He always used to say in a very harsh tone, "Find out the records." And I saw the record, found out from the evidence file, I took out the records, gave it. And he said that, yes, he's having experience in trial court. So even at that stage, hardly I think I must have put in not more than 1 or 2 years of practice. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 9/4/2018. It is at page 17. Like here the case number is mistake, huh? It should be 301 of 2010 instead of 307. Passed by so and so and so and so. There are two numbers. One is a district number, so and so, and Lakhimpur FT case number so and so. Comma, declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next para, it is clarified that although in the impugned opinion dated 9/4/2018, comma, the case number has been typed as Lakhimpur FT-1, case number 307 of 2010. Comma, but the member, comma, foreigners tribunal first, Lakhimpur, by communication dated 3/2/2025, clarified that the said opinion was passed in the proceedings of FT-1, case number 301 of 2010, within bracket, district DIST, district number 555 of 2007. Full stop. The error in the typographical error which is crept in the case number given in the impugned opinion resulted in a wrong record of so and so case number 307 of 2010 being called for. And thereafter, pursuant to order dated 6/1/2025, passed in this writ petition, comma, the clarification was issued by the learned member, comma, foreigners tribunal, first Lakhimpur, accordingly, comma, notwithstanding that in the opinion dated 9/4/2018, the case number is noted as Lakhimpur FT-1, case number 307 of 2010. In view of the typographical error, the same is hereinafter referred to as Lakhimpur FT-1, case number 301 of 2010. Ms. Verma, that is sufficient? Next one. In view of the order which is being, which is proposed to be passed, the pleadings and evidence on record are not been adverted to. Next paragraph. Next paragraph. On a perusal of the tribunal's records, certain documents had been noted, had been seen, which is not a part of the evidence tendered by the petitioner, nor and therefore does not form a part of the opinion. Full stop. Under such circumstances, the learned standing counsel for the FT matters has made an objection to the effect that in view of the ratio laid down in the case of counsel for Ms. Verma, what is that name? Counsel for? Yeah, what is that name? Counsel for so versus Bikartan Das? What is that?
That is the certiorari lordship,
Counsel.
council of lordship and guild. Central Council of Research in Ayurvedic Science.
Just a moment. Please repeat that again. Central Council.
Reported in
Central Council.
Central Council of Research in Ayurvedic Science versus Bikartan Das and others.
Bikartan Das and others. 2023 SCC Online SC
996.
996. And it is submitted that as this court is exercising certiorari jurisdiction, materials which are not placed before the tribunal ought not to be looked into by the court. Next paragraph. On a perusal of the materials available on record, the court is of the view that although the petitioner had submitted the relevant documents for the learned tribunal, but perhaps the petitioner was not correctly given legal advice as to how the case of the petitioner is to be presented before the learned tribunal. Full stop. It is noticed that along with the written statement, the petitioner had submitted a copy of the opinion dated. So what is the date of this opinion?
16.
No.
23/8/2010. And FT case number 47/2010. Well, left side corner, my left and above.
The date is not visible.
Definitely visible.
Mm-hmm. 23/8/2010 and legacy. The next page of that.
What is the date of that opinion of your brother?
It is 20.
Looks like 23/8, lordship.
Which page you are looking at?
This is a Xerox copy he has.
Yes.
I'll say DD. Deputy Logwan hai. Lordship, it's there in the records also.
Date is not there.
Here, he has a copy.
No, just tell us the date.
It is 23/8.
23/8/2010.
2010.
23/8/2010. Passed by the learned member, Foreigners Tribunal, Lakhimpur. In LFT case number 47/2010, within bracket, DIST, district full stop, number 595/07, which is the proceedings against Sri Shankar Debnath, SANKAR, Shankar Debnath, DEBNATH. Full stop. In the written statement, while annexing the said document, it has been projected that the said person is the brother of the petitioner. Full stop. The copy of the said opinion has not been exhibited by the petitioner along with his evidence. Full stop. Next paragraph. However, the court takes note of the fact that when the notice of the proceedings of FT case number 301/2010, bracket district DIST, district number 555/07, was served on the petitioner, the same was received by Sri Shankar Debnath, SANKAR, Shankar Debnath, who mentioned that he was the brother of the petitioner and son of late Radhesham Debnath, RADHESHYM, Debnath, DEBNATH. Stop. Next paragraph. Therefore, the court privacy finds a connect between the petitioner as well as the proceedee of LFT case number 47 of 2010 within bracket dist stop number 595/07. Stop. However, it is clarified that court is not rendering any opinion as to whether there exists a relationship between the said proceedee and the petitioner herein. Stop. Next, but under the circumstances, court is of the considered opinion that as the petitioner projects that his brother was declared to be not a foreigner, petitioner be granted one opportunity to prove any other document on which the petitioner intends to rely upon. Stop. Accordingly, without examining the evidence rendered by the petitioner on merit, on a primary satisfaction that the petitioner deserves an opportunity to prove any other document on which to prove his connection with the proceedee of LFT case number 47 of September 2010. The court is inclined to set aside the impugned opinion dated so and so, passed by so and so and so and so. 301 it will be. Next one. The matter is remanded back to the said learned tribunal with following directions to the petitioner. Next paragraph. The petitioner shall appear before the said learned tribunal on or before. Yes. On or before 23/6/2025. And he shall produce a copy of this order as well as his additional written statement as well as a prayer before the said learned tribunal to allow him to file additional pleadings. Stop. And thereafter, subject to whatever order that is passed by the said learned tribunal, do the needful to appropriate do the, in support of his case. Next para, it is. In the event the petitioner does not appear before the said learned tribunal within the time allowed, comma, it would be open to the said learned tribunal to treat the petitioner as absent on call and pass appropriate orders in the proceedings. Next, it is clarified that as the petitioner is, as the order is passed in the presence of the learned counsel for the petitioner, comma, petitioner is not required to be put to notice of the commencement of proceedings before the learned tribunal. Next para. On appearance of the petitioner before the said learned tribunal, comma, would be open to the said learned tribunal to pass such orders that they be deemed fit and proper as and in accordance with law. Next para. As this order has been passed under unique circumstances, which is unique to the present case, comma, this order shall not be cited as a precedent for any other matter. Next para. The registry shall return back the tribunal records expeditiously, along with a copy of this order to be made a part of record. The petition stands allowed to the extent as indicated above.
Lordship, we are ready with item 8 also, Lordship.
Item 34 we are calling right now.
34, Mr. Paying will need to come, Lordship. He's on legs. We have informed him.
You informed him.
Let he come, my lord. Fact is this, my lord. Let they take time. I have no objections. Put the record says come, my lord. I have also produced the record. Same, my lord. Same put all this. All the documents, same documents put this. His elder brother examined in earlier case. Then, my lord, in second case, I have not received any notice, nothing, my lord. Suddenly I arrested, I am in detention camp. The bail may be granted, then the entire matter may be heard, my lord. Entire may be heard. See, he is in jail.
Oh, hearing is
Lordship,
something I
I
start
have
doing
seen-
it from motion side.
Yes,
From motion stage, I start doing the hearing.
Lordship, I have
Motion,
seen-
admission, hearing, every stage I hear.
Lordship, yes, Lordship, yes. I
My
have
friend
seen-
or two occasions produced the record.
Yes, Lordship.
No, this is, we are
I-
taking up item
I-
34.
Yes, Lordship.
Hmm.
LCR is with us, Lordship.
Hmm.
Yes, Lordship, I have seen the record, Lordship, and
Yes.
Lordship, everything is matching, Lordship.
Name
But Lordship, his wife's name is also matching, Lordship. Except father's name is not matching, and he is now saying that he is Motiur Rahman, who is declared Indian in earlier proceeding, Lordship, and Lordship, and this proceeding is in respect of Mufia Rahman. Lordship, all these matters are, Lordship, matter of factual determination, Lordship, and appropriate.
Just give us a record for a time.
Yes, yes,
I
Lordship.
only wanted to see one thing. We'll send you the records. It's just something we want to examine.
It will also call page 33 in notice.
Just a moment.
Yes. Number to solve. 76 or 65. 66. If it's same number. 20, the other 20. 70. 97 no? Hmm?
Mr. Sharma, you'll have a Hobson's choice. We are sending you the records.
Not sir.
We are putting up 2 flags and giving you your Hobson's choice.
Yes. Not.
Only those 3-4 lines first.
Yes, Doctor.
So this witness refers to the proceedee.
Yes, Doctor.
Correct.
Yes.
Now next flag. Now what is the name of the proceedee here? Witness says about whom?
Muhammad Mutiar Rahman.
Yes.
And here, Lordship, here
Mutiar.
also Mutiar Rahman.
So therefore, who is the proceedee?
Mutiar Rahman.
But the reference is again Mufiar.
Yes, Lordship.
Then you have option choice. Either you say that.
But enquiry is against Mutiar Rahman, Lordship.
No, we understand. So if the inquiry is wrong, that's the Hobson's choice you have.
Lordship.
Deep sea and the devil.
Lordship.
So we grant him bail.
Lordship.
You show it to Ms. Verma also, she will understand.
It's just case law.
No, because two is better than one.
Yes, yes, Lords.
Huh? At times, yes. Okay.
কিছু করা নাই নাকি? রেকর্ড করে দিয়েছে। রেকর্ড করে দিয়েছে। রেকর্ড করে দিয়েছে। নোটিশ ইস্যু করে পড়া কথা। এইটা জানে কি লেনদেন জানে। হুম? এটা চলবে। স্প্ল্যাশ ফর্ম স্প্ল্যাশ করে দিতে পারেন।
Otherwise, it is a clear case of questioning.
Hmm?
Otherwise, the second case is liable to be questioned.
No.
No. It will come on file and hearing.
Because
That reference was in respect of Mutiur Rahman, son
Son of Kalimuddin.
Yes, Lordship. And
That's the difficulty.
And Kolimuddin and Khalilur are same person. There is no proof at all, Lordship.
There's no proof
Except-
at all.
Yes,
That's
Lordship.
that's the problem.
Yes, Lordship.
No, because there also we have an answer, but you come to page 20 of the brief. We have an answer, but we have not been able to connect because you've seen page 20.
Yes, Lordship.
At page 20 is third line. Father's name is Kalimuddin alias Khaliluddin.
Yes,
Therefore, he admits his father's name to be both. Therefore, his present stand that he is not the
Yes,
same
Lordship.
procedure fails.
Yes, yes.
There's something we had not been able to connect.
Yes.
You see it at the time of
Hearing.
hearing. Mrs. J. Ahmed, and counsel for the petitioner. All the respondents are there. Mr. Islam on behalf of Mr. A. Ali. By you see, pursuant to the orders passed earlier, the records of records relating to case number, page 40, BPT so and so 1306 of 2017 is received. And accordingly, the learned counsel for the petitioners prayed for bail. He has been arrested
Yes,
on
20/12/2024.
on the ground that the petitioner was taken into custody on 20/12/2024 pursuant to the opinion dated ex parte opinion dated 25/7/2022 passed in page 40. Next paragraph. The learned counsel for the petitioner has submitted that in there was a previous proceeding against the petitioner, and by an opinion dated 25/1/2011, page 19, passed by so and so, comma, petitioner was declared to be an Indian citizen by birth. Full stop. Accordingly, the records of both the cases were called for and are received by the registry and placed before the court. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground of mismatch in the name of the petitioner and his father. Next paragraph. Be that as it may, comma, as there is a projection in this petition that he is the proceeding in the previous opinion dated 25/1/2011, passed by so and so, page 19, comma, the court is of the considered opinion that as the petitioner was apprehended on 2012/2024 and has spent around 5 months in custody, comma, the pending hearing of this petition, comma, the petitioner be released on bail on the following conditions. So 3 conditions are there. Below rupees 5,000 to the satisfaction of SP border Borpeta. Okay. Next para. As the records are received, comma, the court is inclined to issue rule reasonable forthwith without requiring any fresh steps to be taken. This is the matter for hearing. In the month of July 2025, after summer vacation, on a date to be fixed by the registry.
Not earlier record was in my custody, Lord. That I have.
Okay, just before that, you say that the Mr. G. Sharma, learned standing counsel for the FT matters, has returned the tribunal's records, comma, which is kept in record. Yes, item 8.
Okay, in this case also, Lordship, I have seen the LCR, Lordship, and Lordship may proceeding never exhibited any document in her evidence or Lordship. In anywhere, Lordship, he never exhibited any document, even in order of the tribunal reflected that there is no exhibits.
You understand that?
Yes, Lordship, but Lordship, how it was happened, Lordship, I don't know, Lordship. So regarding that, I leave it to your Lordship, Lordship. Yes, sir. Oh, I have read all the orders, Lordship. Regarding exhibited documents, Lordship, there is no mention, Lordship. So
This is the difficulty in this. Mr. Siddhar, you and few others should do some pro bono work
My lord.
for upgrading the lawyering skills. It's really horrible.
How it was exhibited, Lordship, even signature is also there, Lordship. It was
You were arrested.
No, my lord, no. We are on, I'm on bail, my lord, I think, my lord. There is a bail. I'm not in custody, my lord. Punished with this, litigation. Exhibit 1.
এটা কে কৈ আছো আমি অৰ্ডাৰটো চাওঁ আৰু এভিডেন্সত চাওঁ একো এক্সিবিট কৰা নাই সিহঁতে একো এক্সিবিট কৰা নাই এক্সিবিটেড
Member.
Mr. Siddhar, very horribly conducted.
My lord.
All the documents are photocopies.
My lord, the member signature is there, my lord, as an
We
exhibit.
understand, but
but how
how it has happened, we don't know. That's why we send the records to him to examine
Dada.
it. It's really sad. Mr. Siddhar,
My lord.
we have not made up our mind in the bench. Let us look into the records. If required, we'll list it again on Thursday or Friday.
Look,
My lord.
We have
I'll take one. I'll make it 23.
My lord, not 23, my lord. I have some problem on 23rd.
on 23 of difficulty. So 26th then,
My lord.
or just be there at 2 o'clock. If we can discuss in the bench, we'll tell you at 2 o'clock
My
today.
Hmm?
We'll not hear the matter, but we'll see what can be done. If required, then we'll list it on Monday.
Right.
Just we'll go through the records.
Monday की तारीख है?
Monday is 26th.
Yes, my lord.
Oh, sorry, 26th.
On 27, my lord.
28.
No, those days
22nd or 20th?
we are hearing those APSC matters. It's very difficult to adjust time. And we have two special bench which is also there in the between. So Tuesdays and Thursdays, maybe those
Next
special.
Wednesday, Lordship. Wednesday, next.
Just wait till 2 o'clock, then we'll say.
Well,
If it has to be adjourned, we'll adjourn it on Wednesday. Okay. But let us.
May I please your lordship? I recommend item numbers 16, madam. Kindly pass over for that.
Oh, it goes by default. We'll go through it and tell you because it's Tuesday and Thursday we have a special bench. That's why the difficulty. We'll go through it and tell you at 2 o'clock to be
Right.
done.
May I please, Lordship? Lordship, item number 17, Lordship, petition are already expired, Lordship.
But there are consequences. What do you want?
Lordship, then matter may be adjourned after 2 weeks.
Okay, item number
17, Lordship.
17. Also is represented. Mr.
Rahman.
M. Rahman, and counsel for the petitioner submits that as per instructions received by him, the petitioner has expired. Mr. How he prays for some time to obtain instructions and address the court. List after 2 weeks. Mr. Sigdev, that was your matter.
My
Previous matter was your matter.
Item number 8.
We are thinking of remanding the matter to the tribunal because there's no order sheet to show that why the documents were signed, why the other documents were not signed.
Yes, Lordship. But one observation is here, Lordship, in page 49, Lordship, where a learned tribunal observed that in the instant case, learned AGP has raised the point that evidence on affidavit submitted by the proceedee, the documents are not properly exhibited, and the documents submitted by the proceedee are not proved in original, which is a major loophole on the part of the proceedee.
No, we understand, but you see, that is the reason.
Yes, Lord.
That is why we gave you this record.
Yes.
In fact, what has happened, if say, let us say 2 documents were signed, out of 6 documents, 2 documents were signed. Now, order sheet does not say why 2 were signed and why 4 were not signed.
Yes.
And this evidence were recorded before argument.
Yes, yes. Lord.
So therefore, if this has come on record,
Yes.
then why at the appropriate time objection was not raised?
Lord.
You see, when the documents are tendered in evidence, objection, if any, must be raised there and then.
Yes.
This is not a case of Order 18 Rule 4.
Yes, Lord.
So therefore, once the evidence is tendered, objection must be raised then. Subsequent registration, submission of a objection.
Yes, sir.
The difficulty is that as a lawyer, if an objection is raised there and then, it is within your hands to take a call and how do you respond to that objection.
Yes, yes, Lord. Yes.
But if at the time of writing of the judgment, if the manner of proof is enough, that is as good as an ex parte opinion.
Lord.
You can't rectify it thereafter. But there are 2 things: mode of proof and manner of proof.
Yes.
There lies the difficulty. So send it back.
No, deeply obliged.
Just put a flag on what you had read.
Lord.
Just put off a flag.
My lord, there is one point, my lord. Proof not original. It's certified copies which are certified copies. Then it's not required to be public documents.
Because Mr. Sikdar, there you don't have a chance. At that point, you don't have a chance because of the fact that in your evidence, you have stated that it is a photocopy. Look at your evidence. In your evidence, you say every document is a photocopy and marked as Annexure 1, 2, 3, 4. So
We have the proceeding also submitted the certified copies.
but then you see what will we at the time of decision making, what will we see?
Page 49 of the repetition, Lordship. Second para.
No, just flag it up.
I am
Mr. Sikdar,
reading, Lord.
My lord.
at the time of hearing, let us say that this is a trial court for the time being. At the time of hearing or time of judgment writing, what is the document which we'll rely upon?
My lord, documents which were exhibited
No.
and marked.
It is the evidence which will rely
Evidence, yes, my
upon.
lord.
The fact
Evidence.
is that if in your evidence you say that it is a photocopy,
Yes.
then am I supposed to discard your evidence and then say no, it is an original?
No.
Your affidavit overrides.
Yes.
That is a statement on oath. That's why we are saying you don't have a chance if you make that argument. The record should go to you, you see it and then give us your input on that. Let's see, Mr. A.R. Sikdar, counsel for the petitioner. All the respondents are there.
AI Ali for election.
A.I. Ali. Okay. No, Mr. Islam was there.
Yes, Lordship, on behalf of AI Ali.
I'm Islam on behalf of A.I. Ali. Okay.
Deeply obliged.
Yes, Mr. Chaudhary.
May it please.
We'll request you to make a concise statement because
I will.
Now it is called, you have to zip it.
2020 now.
Huh?
2020 cricket. knowledge.
2020 now.
So, Manoj, I had
Here lies the difficulty. I don't watch this game. And so therefore, instead of 2020, I was in zip file because this is now we get.
I quite see.
Yes.
Manoj, I'm appearing, Manoj, in item 79, Manoj. That's
And
writ
that
appeal
was
number 14 of
14. Huh?
2020.
Yes.
I had addressed your lordship, my lords, on the entire gamut of the case, my lords. The findings of the learned single judge. And, my lords, the fact that the order of discharge, my lords, that's something, my lords, something turns on that. The order of discharge, my lords, was passed in exercise of powers under 19 of the Assam Transport Service Rules. So
Yes.
this, my lords, your lordships will have to distinguish with the cases, my lords, like Inderpit Singh Kelon, etc., including state of West Bengal. Those are cases of en masse cancellation of the entire selection process. Then, my lords, the power is not under the rule. And that distinguishing
Then the power
is not under the rule. The power exercised, my lords, for discharging the officers concerned is not exercised under the rules. The power that is exercised is, my lords, the power of the state to cancel the entire process if it is so tainted or fraught with so much fraud, my lords, on the face of it, that it is difficult, my lords, to take out the tainted from the untainted. In our case here, my lords, it is not the state's case that the entire process is vitiated. In fact, officers are still continuing. The only basis on the basis of which, my lords, the tainted has been tried to be taken out, my lords, is on the basis of police investigation reports. I have pointed out, my lords, that the reliance on police investigation reports, my lords, cannot be conclusive, my lords. It is fraught with dangers. It is tentative in very nature. And police investigation reports, my lords, are used, the reported cases, so only in a case where there are large-scale anomalies, findings, my lords, of large-scale anomalies resulting in the cancellation of the process itself, that the process itself, my lords, has been compromised. Now, this distinction, your lordships will find at paragraph 40 of Inderpit Singh Kalon judgment, my lords. That's a volume 3 I have given to your lordships, my lords. That, my lords, Mr. Dwivedi's submission is recorded. It's a thin volume, my lords. The spiral bound volumes, my lords. Yes. Lordships will keep the volume. I'll quickly take the lordships to the relevant part. But this paragraph 40 of Inderpit Singh Kalon is important, my lords. Unlike our case, my lords, where the exercise of power is under the rules. Volume 3, my lords. Page 28. I'll just take a lordships to the relevant part. Page 28, paragraph 40.
Mr. Mishra.
Sir is ready and charged up.
The difficulty is with this volume.
Yeah.
There's no paperweight of discipline here.
Yeah.
Discipline as a paperweight should have been here.
But just for a lordship's convenience, because otherwise, my
No, it's okay.
judgments have been handed over. I will give
Mr.
give my-
Chaudhary, there are few
give my
people.
senior also, my lords, a compilation.
There
So
are
that
only
whatever he's relying upon, my lords, he can
there are
refer
only
to
few
the.
people before him. I can smile and then let off my steam. You are one of them. Mr. Mishra is one of them. So that's why, just to tone down, I take this shortcut recourse. Yes.
So, page 28, para 40, my lords. This is the distinguishing factor which the Supreme Court notes, my lords. Please see, my lords.
Volume 3.
Volume 3. It's a thin volume. But सबसे पतला. Yes.
Page number
28. Running page 28, my lords. This is Inderpreet Singh Kelon, my lords,
Yes.
relied upon by Mr. Diganta Das also, my lords, on
Yes.
page 28, para 40.
Yes.
Your ladyship has, I'm grateful. We at the outset would furthermore notice that having regard to the submissions made before us by Mr. Dwivedi and Mr. Rao, that the services of the appellants before us were terminated not in terms of the rules, but in view of the commission of illegality in the selection process involved. We need not consider the applicability of the relevant provisions of the statute as also the effect of the provisions of 311 of the Constitution of India. So it's a power balance which is exercised by the state. But moment you go under the rule, my lords, the state, my lords, is under an obligation to comply with the rule. And obviously, my lords, with the mandate of Article 311(2). So this is, my lords, the distinguishing factor, my lords. Paragraph 41 gives the three-pronged test which Mr. Das, my lords, had already submitted, my lords. I'll not repeat, my lords. That if, how, my lords, it is to be approached, my lords, in a case like this. In our case, my lords, none of this, the three-pronged test is not satisfied. It is not their case, my lords, that the entire process is compromised. So, my lords, while this tainted from the untainted, my lords, is on the ipse dixit, my lords, of the government.
But again, in this, when you are citing this paragraph 40,
Yes,
it's come to paragraph 42.
Yes, my lord. Yes.
But
Once such findings was arrived at, all appointments traceable to the officers concerned could be cancelled. But admittedly, although there had been serious imputations against Sidhu being at the helm of the affairs, all decisions made by the commission during this tenure are yet to be set aside. We do not intend to enter into the said controversy. So, my lords, Inderpreet Singh Kelon then remanded the matter back to the High Court. Justice Sinha directed, may I just have the directions, my lords, in Inderpreet Singh Kelon, that your lordships will find, my lords, at page 45. The High Court was directed, my lords, to set up a committee paragraph 91 first, my page 45. We having regard to the
this is a majority view.
Yes, my lords. Justice Bhandari, Dalbir Bhandari was the minority view, dissenting, partly dissenting. So, my lords, 91, my lords, we have para 91, we have having regard to the peculiar facts and circumstances of the case, are of the opinion that it is necessary to direct consideration of the matters afresh. We have not been apprised whether in criminal cases any further material has been gathered so as to implicate the appellants before us. Then para 93, my lords, Placetum D, your lordships will see. Records, my lords, some of them have completed the period of promotion. When nearing completion thereof, they presumably have been working to the satisfaction of the authorities. Then para 94, my lords, Placetum E. However, with a view to segregate the tainted from the untainted, and that in the interest of justice, the High Court should be requested to constitute two independent scrutiny committees, one relating to the executive officers and the other related to the judicial office. So, my lords, court directed, you set up a committee. So, committee was set up, my lords, headed by retired judges, pursuant to which Joginder Pal Singh judgment came. Now, my lords, just have State of West Bengal also, my lords, here, my lords, the latest judgment, my lords, of Justice Sanjeev Khanna, Chief Justice, page 85. This also has been placed by Mr. Das, my lords. Starts at 85, at 88. Paragraph 5, if your lordships take, my lords. Here, my lords, the High Court annulled the process.
Yes.
The lordships will see there are 3 lines from that factual matrix, my lords. Page 88. Because the teachers and the West Bengal state, my lords, came to the Supreme Court saying that the High Court erred by annulling the entire selection process based on the CBI report and should have cancelled the appointments of those cases. Well, please have page 90 here, my lords. So it was a case, my lords, of cancellation of the entire process, which the Supreme Court upheld. And page 90, my lords.
Yes.
The third bullet from the bottom, my lords. Fourth, a 4-member committee chaired by Justice Ranjit Kumar Bagh, a retired judge of the High Court, was formed. The committee included representatives from so and so. So, my lords, all these cases, my lords, where, my lords, the segregation has been done between tainted and untainted, or, my lords, that there is a recommendation for cancellation of the entire process, my lords, has been done, my lords, after constituting a committee, a neutral body who has gone through, my lords, the cases. Now, please have here, my lords, page 95. Lords, the Supreme Court, my lords, refers to all the judgments, my lords, from page 92, para 7, my lords. And please come to paragraph 19 at page 95.
Yes.
The following principles emerge from the aforesaid discussions. So, my lords, it refers to all the judgments and culls out. When an in-depth factual inquiry revealing systemic irregularities such as malice or fraud that undermine the integrity of the entire selection process, the result should be cancelled in its entirety. So, if there is an in-depth factual inquiry, which has not happened here. B, the decision to cancel the selection en masse must be based on the satisfaction derived from the sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable certainty of systemic malice. The probability test is applicable. Next, my lords. Despite the inconvenience caused to untainted candidates, when broad and deep manipulation in the selection process is proven, due weightage has to be given to maintaining the purity of the selection process. This is not the case here, my lord. And the last one, my lord, I'm laying emphasis on individual notices and hearing. Please see, my lord. Individual notices and hearing may not be necessary in all cases for practical reasons. When, my lords, when the facts establish that the entire selection process is vitiated with illegalities at large scale. So, my lords, you will dispense with individual notice if, my lords, the entire selection process is compromised, my lords, and vitiated at a large scale. So, my respectful submission is, my lords, a sequitur from this finding of the Honorable Supreme Court is that if the entire selection process is not vitiated, and you are, my lords, now aiming at a few selected officers, then, my lords, notice is required. I hope I made myself clear, my lords, that if the entire selection process is cancelled, you're not required to, it's not incumbent, my lords, on the authority to issue notice. Because it may not be necessary. Everyone has been treated, my lords, at par. But if you pick and choose, or there is a particular group whom you are targeting, then, my lords, notice would be necessary.
Again, in a lighter note, you have made your point, but whether we have understood or not,
No, my lord. That is beyond doubt, my lords.
We'll have to go with an impression that we are.
No, my lord. That inference, my lords, we all at the bar. That inference, my lords, will be a fair inference from everyone here, my lords, sitting. I'm sure. There's no doubt on that. That's why, my lords, we are laboring, my lords. My lords, now, I had, my lords, pointed out, my lords, Rule 19(2) itself, my lords, that at the stage of subsequent verification, my lords, you have to give a hearing because this is nothing but an inquiry, an investigation you are conducting. So, my lords, in that aspect, will your lordships just have volume 1, my lords? I'll quickly take your lordships to a relevant part. Volume 1 of the compilation. Volume 1, my lords. I've given an index, my lord, with the paragraph numbers and the page numbers. Please have, my lord, the extracts from Black's Law Dictionary at page 2.
Yes.
On the left-hand side, my lord, verified. Lordships has that, my lord?
Yes.
Page 2, verified. To prove to be true, to confirm, or establish the truth or truthfulness, or to authenticate. So when you confirm, when you try to prove to be true, my lords, this is the verification process. Also at page 4, my lords.
Just a moment.
The verification that is defined is, my lords, what is done under oath, my lords. That affidavit which is verified, my lords, formal declaration. But I'm referring to the definition of the word verified.
Because
Lordship is looking for something.
because we have only this legal dictionary. You see, there's a difference of the word verify, as we know in a usual dictionary and a legal dictionary. In a regular dictionary, Oxford's or anything, you will find it is to be just to check the facts.
Inquiry. In fact, Oxford supports me the best. Oxford says, my lords, the process of establishing the truth, accuracy, or validity of something.
But in legal dictionary, it will always find proved. Because they go by the definition of proof under the Evidence Act. So therefore, verification for the legal dictionary
Yes,
would
madam.
be a standard of proof,
To prove,
which is not there in the regular dictionary,
Yes,
which
yes.
we normally understand.
I'm grateful, my lords. In fact, my lords, Black's Law Dictionary verification, my lords, they are concerned with a formal declaration made in the presence of an authorized officer, like a affidavit or a
Because that is what the legal term is,
verification,
verification,
authenticate.
authenticate. But that is why you will find that even when we, in a usual term, say that statements made in the affidavit is verified as true to the knowledge.
Yes, we'll go to the verification clause to say.
Verification clause to say that. So that's the small thin line of difference between a
Difference between
usual
a normal.
dictionary and
Yes, I'm grateful, my lords. Now, my lords, Collins
yes,
Dictionary, my lords, at page 4, my lords, I've extracted.
yes,
Right hand side, my lords, verify. My lords has that.
yes,
Verified, verifying, verify. To check the truth of something by investigation. To prove something to be true. Verifiable, verification, Latin word, my lords. And similarly at page 6, my lords, is the extracts from the Oxford Dictionary. So, my lords, the word subsequent verification, my lords, in my respectful submission, my lords, is nothing but an inquiry. Page 6 also, my lord, in the middle column, verification. My lords has that.
yes.
The process of establishing the truth, accuracy, or validity of something. And then it says verification of official documents. So, it's the process of establishing the truth.
Here again, this verify,
Yes,
make sure or demonstrate that something is true, accurate, or justified.
yes, my lord.
His conclusions have been verified by later experiments.
Hmm.
So this is what I was trying to explain.
The distinction between, my lords, the legal dictionary and a. My lords, I had, my lords, in the course of my argument stated, my lords, that the principles of natural justice will to be read into, my lords, the Rule 19.2, my lords. And in that aspect, my lords, I'll just take a lordship to page 26 at 27, my lords. Same compilation. I'm just quickly running through this, my lords. This is Banyan on statutory interpretation.
It is good you thought of it, at least to give it in the compilation.
It's easier, my lord, because especially in my lord's batch cases, my lord, all advocates are relying on judgment, but ultimately it becomes a bundle for your lordships to.
No,
In
at
fact, my
least
lord,
the presentation of the dictionary, that is
yeah.
something very good.
In fact, my lord, Mr. Ashok Desai, the former Attorney General, is no more. In batch matters, always used to print even his written submissions in a different color. He says, you see, there are so many written submissions before yours should stand out. So he will give it in yellow or in blue. Page 27, my lords.
Yes.
The principle of law, my lords, of Banyan. Section 26.3, law should be fair and just. It is a principle of legal policy that law should be just and that the court decision should further the ends of justice. The courts, when considering in relation to the facts of the instant case, which are the opposing constructions of the enactment, would give effect to the legislative intention, should presume that the legislature intended to observe this principle. The court should therefore strive to avoid adopting a construction that leads to injustice.
This is something we can't accept when we pay income tax. Law expected to be just. You do all the hard work, get an income, and then you go and pay tax. And then you say it is just.
Reading further, Malak. The courts
Yes.
should therefore strive to avoid adopting a construction that leads to injustice. The courts nowadays frequently use the concept of fairness as a standard of just treatment. Comment, Malak. The courts will seek to construe legislation so as to produce a result that is fair and just. This is on the basis that Parliament is presumed not to intend consequences that are unjust, unfair, or unreasonable. There is also a link here with the idea that courts should seek to avoid a construction that produces absurd results. Let's just turn the page, Malak. Where Malak are on the application of addition is extracted. The next para. The concept of fairness and justice in this context have a wide meaning and are broad enough to encompass what may be described as social justice. Injustice may, of course, means different things to different men. Nevertheless, the courts are always concerned to see that there is not a failure of justice. Now, page 30, section 26.4. Procedural fairness.
This, where are you reading?
Page 30,
30.
Yeah. Section 26.4 of Banyan, procedural fairness. It is a principle of legal policy that law should uphold principles of procedural fairness or natural justice. The court, when considering in relation to the facts of the instant case, which is of the opposing constructions of the enactment, would give effect to the legislative intention, should presume that the legislator intended to observe this principle. That principle of natural justice ought to be read into it. Comments. Duties of procedural fairness or principle of natural justice will sometimes be used to supplement a statutory scheme operating as an implied limitation on judicial or administrative decision taken under enactment. So where wide powers of decision making are conferred by statute, it is presumed that Parliament implicitly requires the decision to be made in accordance with the principles of procedural fairness. This is manifestation of the principle explained in Code section 26.3 that Parliament is presumed not to intend a result that is unfair. Principles of procedural justice may, of course, be expressly or impliedly excluded, but the application of the maxim expressio unis exclusio ulterius, to express one thing is to exclude another, will seldom be enough to exclude the common law rules of procedural justice. Then let's dismiss at page 32. Before I take your lordships to extract from dismiss, your lordships come to page 12, which I was referring in my opening arguments. That famous epigram of Justice Biles. Page 12, lordships has from the bottom, and Bile Justice also said. Your lordships has that?
Yes.
It seems to me that the board are wrong, whether they acted judicially or ministerially. I conceived they acted judicially because they had to determine the offense and they had to apportion the punishment as well as the remedy. That being so, long course of decision beginning with Dr. Bentley's case and ending with some very recent cases established that although there are no positive words in the statute requiring that the party shall be heard, yet the justice of the common law will supply the omission of the legislature. And this judgment, has been followed, with approval in Maneka Gandhi's case, until recently, the words, that the justice of the common law will supply the omission of the legislature. Now, coming to dismiss at page 32. This is one of the standard textbooks, and my lords, it's very heartening to see, my lords, they quote from Indian law. Page 32, my lords, at 35. 6053, your lordship says that, my lord. Oh, my lord,
Page
this is
35,
35, running page 6053.
6053.
Yes, my lord. In terms of entitlement to procedural fairness, different trends are to be noted. Generally, the former distinction between quasi-judicial and administrative acts have now been abandoned. And in India, for example, please see, my lord, the distinction has withered away. Even an administrative order with what they have described as civil consequences must be consistent with the requirements of natural justice. And the phrase civil consequences has been interpreted to include, this is from Mohinder Singh Gill, infraction of not merely property or personal rights, but of civil liberties, material deprivations, and non-pecuniary damages. In its comprehensive connotation, everything that affects a rights citizen in his civil life inflicts civil consequences. This is, from, your lordships will see Mohinder Singh Gill, S.L. Kapoor versus Jagmohan is quoted, Rajesh Kumar versus Deputy CIT is quoted. Similarly, at page 37, the lordship is right, my lord. We may not have to go, my lords, to the justice of the common law. Now, my lords, our Indian law is sufficient enough to, my lords, cover all this. Page 37 also, my lords. In India.
And to be quoted there.
Yeah, and to be quoted in this meet, my lord. Our law is very robust now. And page 37, my lords. If your lordships will read, my lords, around 6 lines from the top. In India, again, my lordship says that.
Page number?
37.
Yes. Yes. In India,
given the court's presumption that Parliament did not intend to contravene fundamental rights, the principle of audio alterum partem has regularly been implied into statutory schemes. Even to statutory schemes, my lord. So what I am submitting is, my lord, that the principles of natural justice, my lord, will have to be read into 19.2, and that subsequent verification process, my lord, will enter a hearing. Now, my lords, the last part of this meet at page 41. 6059, page 41.
41.
Finally, your ladyship has page 41. I'm grateful. Finally, on the issue of exceptions to the availability of procedural fairness, if common law requirements of procedural fairness are to be excluded by statute, please mark this, my lord, it is settled that legislatures must state that they are doing so explicitly. So, my lord, even now that impliedly, my lord, it has been given away, is no longer there, my lord. It is settled that legislators must state that they are doing so explicitly. Then the traditional dichotomies, such as between categories of mandatory and directory requirements, have also fallen out of favor. And for example, the preferred approach in Australia now is to determine whether it was the purpose of the legislation that an act done in breach of the statutory provisions should be deemed to be invalid. It has also been increasingly accepted that a procedural fair appeal, please mark this, can cure an initial procedural unfair procedure. Although again, everything depends on the circumstances. Your lordships will recall, my lords, the single judge, my lord, at paragraph 53 has said that I have given patient hearing running into 18 days. Right, my lord. But, my lord, this your lordships will just record here. In a recent pronouncement of the Supreme Court, Justice Rishikesh Roy, in a 3-judge combination, has said that even at the appeal stage, this cannot be cured. In cases, my lord, where an appeal lies, my lords, both in facts as well as on law, the Supreme Court has said what has not been complied with by the original authority cannot be cured at the appellate stage. That judgment, your lordships, will straight away come, my lords. Serial number 18 of the compilation. It's a recent judgment. Krishnadat Avasti, page 434 of this compilation. In fact, because of a difference of opinion, my lords, the matter was referred to 3 judges. And Justice Rishikesh Roy, my lord, speaking for the bench. 434, your lordships will have, my lords. Justice Rishikesh Roy, Justice Sudhanshu Dhulia, and Justice Bhatti. This is 2025 SCC Online SC 179. Your lordships will first have the facts, my lords. These are validity of appointments of teachers, my lords. Where, my lords, the selection process was sought to be cancelled.
Yes.
Para 2, your lordships will see. The matter is posted before this larger bench on account of the split verdict rendered on 4/4/24 by the 2 learned judges of this court. The case pertains to the validity of appointments made for post of school teachers in so-and-so Gaurihar in the year 1998. 4 civil appeals were filed before this court by 10 persons who are alleged to be relatives of the members of the selection committee and were placed in the final select list. While Justice J.K. Maheshwari upheld the finding to set aside the selection of Shiksha Karmis on account of the violation of the first limb of the principles of natural justice, that is, rule against bias, Justice K.V. Viswanathan has, however, upheld the selection, citing inter alia a breach of the right to a fair hearing. Therefore, in this case, we are confronted with a conflict between the 2 foundational principles of natural justice, that is, rule against bias, nemo judex in causa sua, and the right to a fair hearing, or the alterum partem. Lordships will skip that and come to the relevant part, my lords. Issue at page 453. Whether, my lords, this can be cured at an appellate stage. Here, my lords, a full appeal light. Page 453, para 55. Issue C, your lordship says that. The next issue that falls for our consideration is whether denial of justice at the natural justice at the initial stage can be cured by an appellate body. The earliest decision on the issue was delivered by the High Court of Australia. My lords, your lordships will skip all this decision, my lords, and come, my lords, straight to page 456, para 66. Paragraph 66, my lords. Additionally, a perusal of the order of the collector and the commissioner in revision will also show that they are practically identical. An ineffective hearing at the initial stage, therefore, taints the entire decision-making process, leading to a cascade of flawed orders at subsequent stages. So, when the court says an ineffective hearing at the initial stage, therefore, taints the entire decision-making process, leading to cascade of flawed orders at the subsequent stages. Providing a hearing to the affected individual minimizes the risk of administrative authorities making decisions in ignorance of fact or other relevant circumstances, as it allows all pertinent issues to be brought into light. This process not only aids the administration in arriving at a correct decision, but also enables court to more effectively review such actions. The primary purpose of natural justice is to assist the administration in reaching sound decisions at the outset, reducing the likelihood of decisions being overturned later. Its significance lies in fostering fair and well-informed decision-making at the very first instance. Following the above discussion, it must be concluded the defect at the initial stage cannot generally be cured at the appellate stage. And this is not even an appeal. This is when you come under Article 226, we come in judicial review, where the lordships will look into the decision-making process. Then, conclusion at 68. The principle of audio alterum partem is the cornerstone of justice, ensuring that no person is condemned unheard. This principle transforms justice from a mere technical formality into a human pursuit. It safeguards against arbitrary decision making, and is needed more so in case of unequal power of dynamics. My lords, here, my lords, I am dealing with the state, the all-powerful state. With a stroke of pen, my lords, these officers, my lords, have been discharged. Now, my lords, when I am in this compilation only, my lords, the rest I will, the other relevant parts is I've given in the index, my lords. Just one aspect, my lords, is that my submission was, my lords, if the principles of natural justice is not read into Rule 19.2, then Rule 19.2 confers unbridled, unchannelized, and arbitrary power. And in that case, Rule 19.2 will have to be struck down. That, my lords, that law, my lords, was discussed.
But that is not on the challenge.
It's not on the challenge, but your lordships can read it down. My lords, exercising today, my lords, when I'm before your lordships, my lords, for justice. Your lordships, my lords, exercising powers of
That
judicial.
we have reservations.
No, my lords,
To touch a statute without issuing notice to the state
my respectful submission is this, my lords.
and read it down, or to add something or to subtract something.
Yes, ma'am. Your lordships can read it down. Your lordships have the power and the 226 code, my lords. Today, my
No,
lords,
can is a very descriptive word.
because, my lords, while interpreting the provision, if a lordship is called upon to interpret a provision, my lords,
In this court, I give whenever a submission is made that the court can, and then says that there are representations to be addressed. So lordship will remand the matter back to the authorities. I give a what you call example. It's horrible, but still it's an example. You'll find in Rajasthan, if you check out, terminally ill boy wanted to be the commissioner of police, and his wishes were granted. So a minor who had this last wish while fighting terminal cancer was allowed to be a commissioner of police for a day. You'll find it in the internet. So therefore, I also expressed that I have a wish. I have very limited time now. I wanted to travel to moon by walking and request the government to make a staircase for me. And then I want that this representation should be disposed of. So this is an example I give. So
your
but
lordship
well,
is
that's
saying,
a good
your
way of,
lordship is saying asking for
but
the moon.
there's a good way of saying, because when you go to the religious scriptures, when the powers of Lord Hanuman is invoked, you know the story. His powers were curtailed. He was made to forget about his power, and therefore, when you have to invoke the Lord, you'll have to praise him and then remind him of his powers, and then he jumped from Rameshwaram to Sri Lanka. So before that, there was a study to be made. That's what the epic says. I'm not sure whether it's right or wrong, but that's what the epic says. So you remind the court of the power that you have the power, please do it.
But this is not asking for the moon, my lords.
Is it true?
This is within your lordship's reach.
True.
Now, my lords, in that regard, my lords, CB Gautam is a constitution bench judgment, my lords, which holds that in case it is established that if you don't read principles of natural justice, the provision would be rendered, my lords, arbitrary, then it has to be read into it, my lords. That CB Gautam's judgment, my lords, is in serial number 10. But I will take your lordship to a latest judgment, my lords, of the Supreme Court, which considers all this. That's, my lords, State Bank of India versus Rajesh Agarwal at page 184, my lords. This is, my lords, in fact, I also had the occasion to appear in this matter, my lords, first before the Telangana High Court and then before the Supreme Court, my lords. This is a case which concerned, my lords, the RBI circular on fraud, which enables them, my lords, to declare a borrower as a fraud. And there was no provision, my lords, of a notice to be given to a borrower before declaring him a fraud. So our arguments before the High Court, which was upheld by the High Court, was that an order declaring a person as a fraud has immense consequences against that borrower. So natural justice will have to be read into it. Otherwise, the circular will have to be struck down. Now, my lords, High Court read, my lords, the principles of natural justice into the circular, but Just see, my lords, this judgment of the Supreme Court Justice Chandrachud as it then was, my lords. Starting from page 211, it, my lords, spells out the entire law on natural justice, my lords, audio alteram partem. So I'm relying on this, my lords, rather than taking your lordships again to CB Gautam, my lords, Sahara, etc. And the only exceptions which the Supreme Court says is at the stage of registration of the FIR, there is no notice, no hearing. My lords, D2, audio alteram partem, lordship says, page 211.
Yes.
Paragraph 36. We need to bear in mind that the principles of natural justice are not mere legal formalities. They constitute substantive obligations that need to be followed by the decision-making and adjudicating authorities. The principles of natural justice act as a guarantee against arbitrary action, both in terms of procedure and substance, by judicial, quasi-judicial, and administrative authorities. Lordships will skip that, come below, my lords. The courts generally favor interpretation of the statutory provision consistent with the principles of natural justice, because it is presumed that the statutory authorities do not intend to contravene fundamental rights. Application of the said principles depends on the facts and circumstances of the case. Then the paragraph 37, last 3 lines, madam. At the outset, we clarified that principles of natural justice are not applicable at the stage of reporting of a criminal offense, which is consistent position of law adopted by the court, madam, starting from Win, Chadda, etc. Then let's please turn over the page, madam. Follows Bina Pani Day, madam. Your lordships will just mark, madam. Bina Pani Day was a case, my lords, which involved a pre-recruitment anomaly. Namely, my lords, she had given a certificate of age, which later on, my lords, on inquiry was found to be false, that she had given a false certificate. And she was immediately compulsorily retired. So that came before the Supreme Court. Honorable Supreme Court says that while doing that, you will still have to give him a hearing. So for the Honorable single judge to say that no judgment has been cited to show that pre-recruitment anomaly can also fall within the part of misconduct, may not be correct, because Bina Pani Day is there. There are 2 other decisions which were cited before the single judge, namely Mahipal Singh Tomar and another judgment of Chaudhary, which my friend Mr. NNB Chaudhary had relied upon, which Ratnesh Chaudhary, 2015. Both those concern pre-recruitment anomalies. Now, your lordships will now come to page 213. That also your lordships will skip. Let's come to page 219, my lords. No implied.
Just a moment.
D3, my lords.
Just a moment.
That Ratnesh Chaudhary's judgment is there, my lords, in volume 2. If your lordships want to take down the page number of that, my lords. And Mahipal Singh Tomar.
We have extensively marked in the copy
Yes,
provided by Mr. Henry Chaudhary.
Now, 219, my lordships will skip that. Come to page 221, my lords. I'm just reading the part, my lords, which I'm emphasizing, my lords. 221, paragraph 17. In Mangilal versus State of MP, a 2-judge bench of this court held that the principles of natural justice need to be observed even if the statute is silent in that regard. In other words, a statutory silence should be taken to imply the need to observe the principles of natural justice where substantial rights of parties are concerned. Even if a statute is silent and there are no positive words in the act or the rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that may be passed, and making it a requirement to follow a fair procedure before taking a decision unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute. Unless there is a clear mandate to the contrary, no form or procedure should ever be permitted to exclude the presentation of a litigant's defense or a stand. Even in the absence of a provision in the procedural laws, power inheres in every tribunal court of a judicial, quasi-judicial character to adopt modalities necessary to achieve requirements of natural justice and fair play to ensure better and proper discharge of their duties. Procedure is again grounded on the principles of natural justice, irrespective of the extent of its application, by express provision in that regard in a given situation. It has always been a cherished principle where the statute is silent, please mark this, about the observance of the principles of natural justice. Such statutory silence is taken to imply compliance with the principles of natural justice, where substantial rights of a parties are considerably affected. The application of natural justice becomes presumptive unless found excluded, please mark my lords, by express words of statute or necessary intendment. It aims to secure justice or to prevent miscarriage of justice. Principles of natural justice do not supplant the law but supplement. These rules operate only in areas not covered by any law validly made. They are a means to an end and not an end in themselves. Then, my lords, lordships will then come, my lords, straight to my lords, paragraph, page 228, my lords, CB Gautam's case is considered. Lordships have page 228.
Yes.
See, in CB Gautam, the question before a constitutional bench of this court was whether a so-cause notice must be issued to an intending purchaser and seller of a property before making a compulsory purchase under 269 UD1 of Chapter 20C of the Income Tax Act. Amit Kania, Chief Justice, speaking for the constitutional bench, held that whether validity of a provision would be open to serious challenge for want of an opportunity of being heard, courts have read such a requirement into the provision. In CB Gautam, this court read the principles of natural justice into the provisions of Chapter 20C to save them from the vice of arbitrariness. The Constitutional Bench held thus. And I'm reading, my lords, the italic portion, my lords, 7 lines from the bottom, my lords, Placetam D. Moreover, I'm reading Placetam D, my lords.
Yes.
Moreover, if such a requirement were not read into the provisions of the said chapter, they would be seriously open to challenge on the ground of violation of the principle of Article 14 on the ground of non-compliance with the principles of natural justice. The provision that when an order for purchase is made under 269 UD, reasons must be recorded in writing is no substitute for a provision requiring a reasonable opportunity to be heard before such an order. Then it refers to Sahara, and the lordships will then come to page 229. When the Supreme Court reads into the circular, the fraud circular, paragraph 93, it has been elucidated in the preceding paragraph that the classification of a borrower's account as fraud in accordance with the procedure laid down in the Master Directions on Fraud entails significant civil consequences for the borrower. Since the Master Directions on Fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account as fraud, the rule of odi alterum partem has to be read into the provisions of the said directions to save them from the vice of arbitrariness. So the Supreme Court, then it goes on the duty to record reasons, etc. And at 231, where the conclusions are, 98.6. 98.6 and 98.7, saying that they will have to be heard. When your lordship is having this volume on hand, now the next permission, and I'll quickly take your lordships to the judgments, is what I made good last time, that the learned single judge, has extensively relied upon seal cover documents and rendered findings on the documents which were produced before the learned single judge in a seal cover. That, my lords, the Honorable Supreme Court has deprecated that practice. The recent trend is, my lords, that it should not be done because it gives an unfair advantage to one party and renders the other parties right under Article 226 OTS. That your lordships will find, my lords. The first judgment is Commodore Amit Kumar Sharma, my lords, 2022 SCC Online Supreme Court 1570. This is running page 314. And quickly, my lords, I'll take your lordships to the relevant part. It relies on Khudiram Das, my lord, the detention judgment, my lord, of the Supreme Court. Please come to page 321, my lord. 321, paragraph 22. These were the proceedings before the Armed Force Tribunal, which came before the Supreme Court. Paragraph 22, your lordships has that, Malad? And my contention, my lords, is that reliance on seal cover records, my lords, documents, results, my lord, in miscarriage of justice and should not be permitted.
Paragraph.
Paragraph 22. It gives an unfair advantage, my lords, to the state, to the detriment of the citizen, my lords, who comes before your lordships under Article 226. Paragraph 22, my lords. Here, my lords, even written submissions were not given, were given in a seal cover. You see that, my lords, just before para 22, my lords, at the top, and Commander A.K. Sharma indicate that the data was submitted in the form of a sealed note. That note was also sealed, my lords. Then 22. Similarly, the board proceedings were not disclosed to the appellants. The written submissions before the court and the submissions in Commander A.K. Sharma before the AFT indicate that the board proceedings were not disclosed to the officers and were submitted to the AFT in a seal cover. The AFT, on a perusal of the board proceedings, has observed that the second respondent had adopted proper procedure and suitable parameters, that it had uniformly applied it. It was observed at perusal of the documents that there was no gender bias and that the appellant's application for PC was rejected only because they were lower in inter se merit. Now have put out the page para 24, my lords. Material prejudice has been caused by the process which has been followed of disclosing the information of vacancies in the board proceedings to the AFT in a seal cover. In Khudiram Das versus State of West Bengal, this court held that the test for determining if material must be disclosed is whether all reasonable probability the material would influence the decision of the authority, ruling in the context of preventive detention, a 4-judge bench of this court observed. Now, the proposition can hardly be disputed that if there is before the district magistrate material against the detinue, which is of highly damaging character and having nexus and relevancy with the object of detention and proximity with the time when the subjective satisfaction forming the basis of detention order was arrived at, it would be legitimate for the court to infer that such material must have influenced the district magistrate in arriving at his subjective satisfaction. And in such a case, the court would refuse to accept the bold statement of the district magistrate that he did not take such material into account and excluded it from consideration. Now, please have para 25, it refers to T. Takano. This is a SEBI judgment. And I will take a lordship straight to para 26. Just the relevant part, my lords. This court observed that right to disclosure is not absolute. Portions that involve information on third parties or confidential information on the securities markets may be withheld by the SEBI. The court directed that the board is duty bound to disclose parts of the investigating report that concerns the specific allegations that have been leveled in the show cause notice. However, the court also observed that it does not entitle the person to whom the notice is issued to receive unrelated sensitive information. The court held that it must first be prima facie established by SEBI that the disclosure of the information would affect third-party rights. So, the burden is on the state. They just can't, my lord, as a matter of course, hand over seal cover documents. The court observed that the right to disclosure is not absolute. I'm sorry, my lord. The court held that it must first be prima facie established by SEBI that the disclosure of the information would affect third-party rights. Once a prima facie case of sensitivity is established, the owners would then shift to the appellant to prove that the information is necessary to defend this case appropriately. The conclusions are extracted below. Now, next page 323, para 28. The elementary principle of law is that all material which is relied upon by either party in the course of judicial proceedings must be disclosed. Even if the adjudicating authority does not rely on the material, while arriving at a finding, information that is relevant to the dispute which would with reasonable probability influence the decision of the authority must be disclosed. A one-sided submission of material which forms the subject matter of adjudication to the exclusion of other party causes a serious violation of natural justice. In the present case, this has resulted in grave prejudice to officers whose careers are directly affected with the consequence. But same here, my lords, in the case of the officers here, my lords, who are before your lordships. Then, my lords, 29. The non-disclosure of relevant materials to the affected party and its disclosure in a seal cover to the adjudicating authority, in this case the AFT, sets a dangerous precedent. The disclosure of relevant material to the adjudicating authority in a seal cover makes the process of adjudication vague and opaque. The disclosure in a seal cover perpetuates two problems. First, denial to the aggrieved party the legal right to effectively challenge an order, since the adjudication of issues are proceeded on the basis of unshared material provided in a seal cover. Same here, my lords. The adjudicating authority, while relying on material furnished in a seal cover, arrives at a finding which is then effectively placed beyond the reach of challenge And secondly, it perpetuates a culture of opaqueness and secrecy. It bestows absolute power in the hands of the adjudicating authority. It also tilts the balance of power in litigation in favor of a dominant party which has control over information. Most often than not, this is the state. A judicial order accompanied by reasons is the hallmark of the justice system. It espouses the rule of law. However, the seal cover practice places the process by which the decision is arrived beyond scrutiny. The seal cover procedure affects the functioning of the justice delivery system, both at an individual case-to-case level and at an institutional level. However, this is not to say that all information must be disclosed to the public. Illustratively, sensitive information affecting the privacy of individuals, such as identity of sexual harassment victim, cannot be disclosed. The measure of non-disclosure of sensitive information in exceptional circumstances must be proportionate to the purpose that a non-disclosure seeks to serve. The exception should not, however, become the norm. Then 30, that during the course of hearing, it has clearly emerged before this court that the material which was relied upon by the AFP for determining the vacancies which are available and for assessing as to whether they were utilized correctly has not been disclosed to the appellant. Then the court set aside this. Then last two lines of paragraph 31. The failure to disclose relevant materials has caused substantial prejudice to the appellant. This case exposes the danger of following a seal cover procedure. Now, this judgment was recently, in a very recent judgment, the Supreme Court, in a Kerala case, where the channel's license was denied, uplinking license of this channel called Madhyaman Broadcasting Limited, was denied by the Information and Broadcasting Ministry. That judgment, is reported in 2023 13 SCC, page 401. At page 325, and I'll take your lordships to the relevant part. Here again, seal cover material was produced. And your lordships will come to E1 at page 371. E1 principles of natural justice, purpose and content. The principles of natural justice were read into the law and conduct of judicial and administrative proceedings with an aim of securing fairness. This principle seeks to realize the following four momentous purposes: fair outcome, inherent value in fair procedure. Then page 372, para 48. Your lordships answer, on when I cited the justice of the common law. Para 48. Indian courts have been significantly influenced by the courts in England on the interpretation, application, and content of natural justice, primarily because the principles are derived from common law and are grounded in the rule of law. The jurisprudential developments across other common law jurisdictions relating to the principles of natural justice usually, if not always, spill over to Indian jurisdiction. Our courts were soon to follow suit when courts in England made a functional distinction between executive and non-judicial action and between so and so. Then the duty to act fairly is paragraph 49, And please come, to the seal cover here, at page 378. Because here, citing national security, the entire material was given in a seal cover before the High Court. Page 378, paragraph 61. Infringement of MBL's right to a fair hearing, 61.3 at the foot, open justice. MHA disclosed the documents in the seal cover to the High Court. The MHA disclosed the documents in the seal cover to the High Court. The High Court dismissed the writ petition by relying on the material that was disclosed solely to it on the seal cover. the relevant material is not removed from the proceedings. The material is only removed from the affected party's docket. The party defending its action, which most often is the state, and adjudicating authority rely on the material while making arguments and while reaching a finding respectively. An ancillary question that must be answered at this stage is whether the three alleged procedural infractions have to be individually or collectively assessed to decide if a right to a fair and reasonable hearing is violated. We are of the opinion that the court must determine if the procedure that was followed as a whole is fair and reasonable. The Lordships will skip that method and come, my lords, to paragraph 66 at page 380. MHA disclosed, the Lordships has that, my lord. I'm sorry, I'm running fast, my lord. MHA disclosed the material forming the opinion for denying of security clearance solely to the High Court. The High Court, instead of deciding if any other less restrictive but equally effective means could have been employed, straight away received the material in a seal cover without any application of mind. Even, my lord, the single judge, my lord, accepted the seal cover records placed by the state, my lords, with the additional affidavit, and also, my lords, the seal cover records pertaining to, my lords, the service records. The High Court, instead of deciding it, if any other less restrictive but equally effective means could have been employed, straight away received the material in a seal cover without application of mind. It is now an established principle that natural justice, that relevant material must be disclosed to the affected party. This rule ensures that the affected party is able to effectively exercise their right of appeal. When the state government claims non-disclosure on the ground of public interest under section 124 of the Evidence Act, the material is removed from the trial itself. As opposed to this method, when relevant material is disclosed in a seal cover, there are two injuries that are perpetuated. Please mark, my lord. Firstly, the documents are not available to the affected party. Secondly, the documents are relied upon by the opposite party, which is most often the state, even in this case, my lord, in the course of arguments, and the court arrives at a finding by relying on the material. In such case, the affected party does not have any recourse to legal remedies because it would be unable to disprove any inferences from the material before the adjudicating authority. Then, para 67. This form of adjudication perpetuates a culture of secrecy and opaqueness. The Lordship has that, Miller, and places the judgment beyond the reach of challenge. The affected party would be unable to contradict errors, identify omissions, challenge the credibility of informants, or refuse false assertions, allegations. The right to seek judicial review, which has now been read into Articles 14 and 21, is restricted. A corresponding effect of the seal cover procedure is non-reasoned order. Now, 68 relies on Amit Kumar Sharma, which I just relied upon, my lords. And please come, my lords, to page 382. Paragraph 69, my lords. Upon the perusal of the material in seal cover, the single judge of the High Court observed that the file submitted by the MHA indicates that the committee of officers took more of the inputs provided by the intelligence agencies and found that the inputs are of serious nature and fall under the security rating parameter. The single judge observed. So and so, Lordships will skip that. And please come to paragraph 70, my lords. I am reading just above Placetam D. The sealed cover procedure, the Lordships has that, my lord, followed by the single judge and the division bench, have necessarily rendered the appellant's right to writ remedies, which has been described as the heart and soul of the Constitution and the basic feature of the Constitution, a dry parchment. The non-disclosure of reasons for the denial of security clearance, which is the sole ground for denying the permission to renew the license, and the disclosure of relevant material only to the court in a seal cover, has rendered the appellant's procedural guarantees under the Constitution odious. The appellant's right to writ remedies has been denied through a formalistic order of the High Court. The procedure that was followed by the High Court has left the appellants in a maze where they were attempting strenuously to fight in the dark. The non-disclosure of reasons for denial of security clearance to the appellants and the disclosure solely to the court in a seal cover has restricted the core of the principles of natural justice, the right to a fair and reasonable hearing proceeding. So, it infringed, my lords. The court said even the High Court proceedings, my lords, infringed the right to a fair hearing. I will beseech your lordships, there are numerous seal covers, I am told, given before your lordships today. Please return it, man. The entire practice has been deprecated, my lords, and it provides an unfair advantage to the state. Then, my lords, it considers national security issues also, and court says even then you have to disclose. And, my lords, non-disclosure, you have to lay the foundation, my lords, in the pleadings itself. if you are seeking, my lord, non-disclosure under the Evidence Act, then you have to lay the foundation in the pleadings itself to say that we cannot give it for security reasons or for anything else. Otherwise, my lord, disclosure is a no. So, my lord, just to summarize, my lord, before that, my lord, two judgments which the single judge relies upon, two decisions which the single judge relies upon. My lords, one is Krishan Kumar and Chakradhar, my lords, OP Chakradhar, which is this is, my lord, at 456 of the impugned judgment. The single judge says, my lord, if your lordship will just have that no decisions have been placed by the writ petitioners which would show that police reports cannot be looked into, my lord. Right, my lord? I had pointed out, my lord, during my arguments that a confession statement is hit under section 25-26 of the Evidence Act, cannot be looked into. 161 statement, my lord, is hit by 162 of the CRPC, my lord, cannot be looked into except for the purpose of contradicting the witness. My lord, 456, the Honorable Judge says, my lord, paragraph 48, no law has been cited on behalf of the petitioners to support a view that there is a legal embargo in acting upon police reports, as seen to be done in the present case. On the contrary, the decisions in Krishan Yadav and O Chakradhar goes to support a contention that police reports can be acted upon. I'm duty bound, my lord, to place the two judgments, my lord, before I end and sum up my submissions, my lord. Lordships will first have the judgment. First have, my lord, the Krishan Kumar's, Krishan Yadav, State of Haryana, my lord, 1994, 4 SCC 165. I'm sorry, my lord, it's not part of my compilation. I'm handing over, my lord. Krishan Yadav.
His citation is
1994, 4 SCC, page 165.
Oh, achha, you're giving it as
Yes.
Okay, okay.
This was a case, my lords, where the entire selection process was found to be, my lords, found to have collapsed, my lords. The Supreme Court found that it was rampant favoritism. The entire process was compromised. The lordships will see that, my lords. In fact, the Supreme Court, my lords, asked the CBI to give a report. And the entire process was cancelled, my lords. So I have, my lord, in my argument stated, my lords, that you cannot rely on police reports to segregate. If the police report is so damning that the entire process, my lords, is compromised, then, my lords, it can be cancelled. Just have, my lords, para 13, my lords. At page 170 of the report, the arguments on behalf of the appellants addressed by their learned counsel, Mr. Govinda Mukherjee and A.K. Ganguly, may be summarized thus. This is a clear case in which various acts of nepotism and favoritism have been committed. The whole selection is arbitrary. Very conveniently, destruction of records is pleaded. Unfortunately, the High Court has not given much attention to the allegations, so and so. Then your lordships will come to paragraph 15. It is not possible for this court to enter into any factual domain and decide the case one way or the other. We have already mentioned about recording the report of the CBI. We will only go by that as the report commends itself to acceptance. In our considered opinion, the CBI has done a commendable job and has not failed to call a spade without shielding anyone concerned, including a minister. We will extract the following from the report. Then it extracts from the report, my lords, how, my lords, the process was completely compromised, my lords. And just have para 16, my lords, at page 174. Having regard to all the above, foot of the page, my lords. Having regard to all the above, the irresistible conclusion is fraud has reached its crescendo. Deeds as foul as these are inconceivable, much less could be perpetrated. We are reminded of the words of Shakespeare. Thus much of this will make black, white, foul, fair. Wrong, right, base, noble. Ha, you gods, why this? And my lords, para 17, it may be too much to draw an inference that all theirs were motivated by extraneous considerations. Otherwise, how does one account for selection without interview, fake and ghost interviews, tampering with the final records, fabricating documents, forgery, etc.? The story does not end here. Selection leaves secret. Now, please come to para 20. In the above circumstances, what are we to do with these damning findings, my lords? Supreme Court says, in the above circumstances, what are we to do? The only proper course open to us is to set aside the entire selection process. The plea was made that innocent candidates should not be penalized for the misdeed of others. We are unable to accept this argument. When the entire selection is stinking, conceived in fraud, and delivered in deceit, individual innocence has no place as fraud unravels everything. To put it in other words, the entire selection is arbitrary. It is that which is faulted and not the individual candidates. Accordingly, he hereby set aside the selection of taxation inspectors. The effect of setting aside the selection would mean appointments held for 96 posts, including will have no right to go to the office. Normally speaking, we would require them to disgorge the benefit, but then Lordships will skip that, Malats. And now come to O Chakradhar, Malats, 2002-3. But this was a case where the Supreme Court said the entire process is thinking. The 2002-3 SCC 146, Malats. This is Justice Brijesh Kumar's judgment, Malad. O Chakradhar. Please see, Malad, paragraph 3, Malad. This was a Railway Recruitment Board examination. And here, Malad, the notice was given as per rules in Chakradhar. That your Lordships will see, Malad, at paragraph 3. Yeah, Malad, the entire process was cancelled, Malad, by the Railway Board. That is at paragraph 3. CBI investigation was there, Malad, and serious nature of irregularities, conduct of selection, had decided to cancel the entire. So, Malad, then your Lordships will skip that, Malad. Para 4, Malad. The Central Administrative Tribunal, while deciding the case, held that merely saying that serious irregularities were committed in conducting the selection or that typing test was not held, such general allegations could not be good enough to take a decision to cancel the whole selection. But please mark, my lord. It also observed that the so-called notice which was issued is silent about any irregularity in selection. Here is a case, my lord, where the so-called notice was issued, my lord, to the delinquent employees, and their reply was sought. Thereafter, therefore, the so-called notice was inadequate and incomplete. It has further been observed that the report of the CBI cannot be the only refuge for cancellation or selection, but its contents should have been brought to the knowledge of the applicants in a concise form to enable them to give a proper reply. But it was not done by the administration. So and so. Number para 5 minutes. The writ petitioners preferred by the appeal against the order of the Central was dismissed as indicated above. The judgment of the High Court in the writ petition is also mainly on the ground of violation of the principle of natural justice, and that the notice which was given to the candidates. Yeah, because notice was given. Court said the notice was inadequate. Now, please have para 6, my lords. Mukul Rodgers, who was then the additional Solicitor General, argued, my lords, relying on Krishan Yadav. Your lordship has that, my lords. Decision reported in, and on the basis of the same, it has been vehemently argued that in a case where irregularity committed in the process of selection is all pervasive, vitiating the whole selection, in that event, it would not be required that each selectee be served with a so-called notice. Now, I pause here for a moment, my lord. The argument says, my lord, in case you cancel the entire process, then notice not required. But if you don't cancel the entire process, my lord, you segregate and you take action against the select few, my lord, then notice would be required. Your lordships will see that in such circumstances, it will be open to cancel the whole selection. Your lordships will come to para 7 now. Refers to Krishan Yadav. And para 8, my lords, I will read, my lords. In our view, the nature of illegalities and irregularities committed in conducting selection which have to be scrutinized in each case so as to come to the conclusion about future course of action to be adopted in the matter. If the mischief played is so widespread and all pervasive, affecting the results so as to make it difficult to pick out the persons who have been unlawfully benefited or wrongfully deprived of the selection, in such cases, it will neither be possible nor necessary to issue individual so-called notices to each case. Your lordship says that, my lord. Same thing, my lord, which State of West Bengal judgment says, my lord. In case you cancel en masse, no notice. But if you try, my lords, to cull out, my lords, tainted from the untainted and take action against the select few, my lords, notice is mandatory. That's what even Chakradhar says, my lords. The only way out would be cancel the whole process, notice to its selectee. The only way out would be cancel the whole motive behind the irregularities committed also has its relevance. The copy of the report has been made available to the court by the learned Solicitor General. Same was served upon learned counsel for a respondent to find out the position present. We have scrutinized the report. So it was given exchange to the parties. Then para 12. As per the report of the CBI, the whole selection smacks of malafide and arbitrary. Lordship has that, Malak. All norms are said to have been violated in impunity each stage with so. Lordship will skip that, Malak. Come to the last two lines. We are therefore of the view that it is not one of those cases where it may have been possible to issue any individual notice of misconduct to each selectee and seek his explanation in regard to the large-scale, widespread, and all pervasive irregularities and irregularities committed by those who conducted the selection, which may, of course, possibly be for the benefit of those who have been selected. But there may be a few who have deserved selection otherwise. But it is difficult to separate the cases of some of the candidates from the rest, even if there may be some. The decision in Kisam Yadav to cancel cannot be faulted, and therefore this is good. So it says, Malats, notices will mean nothing, Malats, because we have decided to go ahead and cancel. So these decided cases, including the state of West Bengal's Baisakhi case, the latest judgment says that in case you decide to cancel en masse, no notice required. The necessary security is, in case you go against the select few, notice will have to be given. Now, just to sum up, my respectful submission is this, the constitutional protection, under Article 311(2) should not be denied, on the ipsi dixit of the authority. They must place material, including, if they are invoking the second proviso to Article 311(2). Court must lean, in favor of the constitutional protection. That's, the decided cases say. If the order is stigmatic, if it is punitive, then the court must, court says, the inquiry should be done. Those are the decided cases, I'll not, Mr. Ken Chaudhary has cited all this. One, your lordships have also seen yesterday, I referred to, page 286, para 64 of the additional affidavit, and para 77 at 293 to show that a preliminary inquiry was conducted, against the appellant. If a preliminary inquiry is conducted, why not a formal departmental inquiry? This, was considered in Tarsim Singh's case. Your lordship will just take the citation, that's volume 2 at page 242. Tarsim Singh says, the lordship will just have that volume, that if you can conduct a preliminary inquiry, why not a regular departmental inquiry? Tarsim Singh, the citation, is 2006, 13 SEC.
Which paragraph is that?
Page 219 of my compilation, at paragraphs 10 and 11. At page 242. That if you can conduct a preliminary inquiry, and that too behind the back, what stops you from conducting a regular departmental inquiry? And if you conduct the preliminary inquiry, you have to comply with the requirements of natural justice. That's paragraph 11 of Tarsim Singh, at page 242 of my compilation. One other judgment, is the Gujarat High Court judgment.
In the present case, who has done that preliminary inquiry in your in this case?
We don't know. They are saying including a preliminary inquiry and the police investigation report. We culled out from the additional affidavit, that's at page 286 and 293.
But there is no clarity who did the
who
did the preliminary inquiry.
No. This, is at paragraph 64 at 286. The lordships will just mark this, where they disclose for the first time that a preliminary inquiry was conducted. Paragraph 64 at 286 and paragraph 77 at 293. Now, the other decision, my lords, on this preliminary inquiry is High Court, Registrar General High Court of Gujarat versus Jayashree Chamanlal, 2013, 16 SCC, page 59. This is, my lords, part of my compilation 2, page 292. At paragraph 3132, my lords, page 312. This is volume 2, my lord.
Okay, we'll have to close because we have to rise for the bench. We'll take note of your submissions, written note of submissions.
Yes, my lord.
This single bench again. So
Just give me a minute, my lord. And my lord, I had also stated, my lord, the distinction drawn between, my lord, by the learned single judge on pre-recruitment anomalies and post-recruitment anomalies, and to say that this does not fall within, my lord, the definition of misconduct.
that you said yesterday.
Yes, ma'am. In my respectful submission, my lord, there is no such distinction in law. The distinction, my lords, has resulted, my lord, in an impugned judgment, my lord, which has, my lord, denied me the protection constitutionally provided, my lord, under Article 311(2). And secondly, my lords, moment the officer enters the service, my lords, he is entitled to the protection under 311(2). It matters not. It matters not, my lords, whether the misconduct pertains to earlier pre-recruitment or post-recruitment.
We have recorded that. Yesterday you said that.
So my respectful submission is, my lord, the dismissal of the writ petitions, my lord, by the learned single judge, my lord, was not warranted, my lord. The single judge, my lord, did not consider, my lord, the case setup, especially, my lord's reliance on seal cover records, my lord, has completely vitiated the impugned judgment. I'm very grateful for a patient hearing.
We continue tomorrow, Mr. Mishra.
Sorry, sir.
We continued.
You remember, you will understand in one word. It's not demeaning to you. It's just on lighter note. Mr. Mishra will remember it immediately when I say it. Yesterday took time, Mr. Chaudhary took time for half an hour. Yesterday took 1.5 hours. So I remember toothpaste.
My lords, I told my friend outside that in cricket, my lords, towards the end of the day, my lords, you must just manage and bat. Tomorrow is another day.
Privately, Mr.
Chaudhary saying
Your voice is cracking up. Mr. Kohli, your voice is cracking up. Your voice is cracking up, Mr. Kohli.
Not sure if it's clear here.
Hi, yes.
I was just saying, Mr. Chaudhary seemed to be indicating that he was a night watchman.
Yes,
He would continue tomorrow.
Yes.
No, night watchman ends when the night falls. Tomorrow is another day.
Tomorrow is another day.
Okay, Mishra sir will start tomorrow.
So let's say the submissions from Mr. Aruna Chaudhary, Learned Senior Counsel, assisted by Mr. B. Chaudhary, the appellant in WA 14 of 2022 is concluded. Am I reserving right to reply? All the learned counsel who are present, please get your name recorded for matters you are. D.K. Mishra, Learned Senior Counsel, assisted by Mr. B. Prasad, Learned Counsel in WA.
I have WA 98 and 196.
98 of 22.
2020 and 196 of 2020.
2020.
2020.
Oh, both are 2020.
20.
Okay.
Item
Is
4027.
present. Mr. N. Kohli, Learned Senior Counsel, assisted by Swenson, as well as Mr. P. N. Sharma. Are present. It appears through video conferencing. As for yesterday's order, at the name of his assisting counsel also. This is the matter is parted on 22/5. Oh, just a moment, just a moment. Okay, just a moment. Tomorrow we will take up the matters in the first half. Because as per the cause list, there's a single bench after, after DV2. And very few matters are listed in the part 1. So, Mr. Vishwa, it will be convenient for you in the daytime? First half? To start as and when there are 2 or 3 items which can be put in division bench. Some change in roster. Mr. Kohli, tomorrow we'll be taking up in the first half.
But that I, no issues, Lord. Yes.
There's a change in roster, so therefore.
I'll submit a note, my lord, in due course of my service.
That's why I started with that paperweight of discipline. Because after 3 volumes again,
No, no, that will be short.